And do you think that could change if Bortland testifies, which we don't think will happen?
I want to go back to the last question real quick. You know, the prosecution always can give immunity to a witness that's got the Fifth Amendment if they really want his testimony, because that can't be used against him in a subsequent trial. Listen, no defense lawyer, nor certainly somebody who has not looked at the file and is not involved in what the defense may ultimately be, is going to make a prediction. Usually the decision as to whether or not a defendant is going to take the stand is not made until after the state's witnesses have all testified. And you have to make a balancing equation when you're consulting your client and say, listen, did the prosecution prove its case beyond a reasonable doubt? Because to use an old axiom that my mentor taught me, juries love to convict defendants from the mouth of themselves on the witness stand. So it is an extremely personal and nuanced decision. Last point, I'd say, Anjanette, the one caveat and curveball when you have a celebrity like this, there's a lot of ego. There's the court of public opinion. There are his fans that he wants to cater to. And sometimes that drives them to do something that's good in the court of public opinion, but disastrous in a court of law. We'll have to wait and see.
We will definitely have to wait and see. And, you know, YNW Melly's fans, I'm sure, want to hear from him. They are very active on Instagram and TikTok. But whether or not he gets up there and puts himself in the hot seat, that's a decision that is totally up to him. His counsel can, of course, weigh in with him and advise him, but in the end, it's his decision to make. Our next question, Terry, I'll send this one to you. Tay from YouTube asks, will the prosecution need, in all caps, the weapon used to get a conviction?
Well, what they need to do is to prove to this jury beyond a reasonable doubt that it was Melly who was sitting in the backseat of that car on the driver's side who shot those 2 kill shots to both of the victims. And what they need to do is to have some forensics. They've already had some experts who came in to try to say that the trajectory of the bullets went a certain way. But on defense, they really did a great job cross-examining those witnesses and saying, look, you don't have the height, you don't have the distance, so this is basically just a guesstimate as to where those shots came from. So if they can't put the gun in Melly's hand and if they can't show where those bullets came from, I think the prosecution is going to have a very difficult time. Plus, the defense has already laid the foundation in the cross-examination and certainly in their opening statement that the investigation was very poorly done. They did not follow up on leads. They did not even follow up with questions to Henry, who is the co-defendant, and that case has now been severed from this trial. But I definitely think that those are the 2 areas. One, the fact that they didn't follow up with these investigations, and 2, the bullets. It's going to make it a little bit difficult for that prosecution to prove that it was Melly who did this. So right now, I think the momentum is on the defense side.
Very interesting take, Terry. And you are there in the courtroom, so we're going to be really excited to hear more from you as the days go on about what it's like in there, sitting there kind of taking this all in and what's going on in the gallery. Facebook question for you, Brian Buckmeyer. Catherine Vargas asks, if there were additional jurors missing today, on top of the one that was in the emergency room, at what point would you call in alternates?
I mean, I don't know why he's not calling an alternate now. You're able to call an alternate for any reason. A juror is stuck in traffic, a juror is sick, illness in the family, whatever it may be. I don't understand why we're waiting on this juror. Maybe it's a fear that if you just give one alternate into the main jury pool, then they'll start, quote unquote, dropping like flies. But any point in time, I don't know why we didn't start early this morning. Maybe the judge wanted the morning off. I don't know.
We don't know. It'll be interesting to know. Maybe they feel like we don't need to call in an alternate. We can just delay a couple of hours. Maybe they don't want to lose one, because this trial could go several weeks from what we have been hearing. All right, everybody, we are going to take a quick break, but we want you to stay with us as we continue to take your questions this hour. So keep submitting them to us on all our social media platforms: Twitter, YouTube, Instagram, TikTok, Facebook. We'll get to as many of them as we can, and stay with us. I'm Anjanette Levy. You are watching Law and Crime. We'll be back in a few.
just one you.
There are many sides to you.
And all of them deserve the best. Introducing Max, the one to watch.
Welcome back. I'm Anjanette Levy, and thanks for joining us here on Law and Crime as we take your questions this hour on the trial of YNW MELLY. There's been a delay because a juror was ill this morning, but that juror is expected to report to court around 1:30 p.m. Eastern Time. So we are hoping that testimony will resume at that point in time. So keep it tuned right here to the Law and Crime Network. Also our YouTube channel. You can watch the feed uncut there. And keep your questions coming to us. You guys have been submitting a lot of great questions, and we'll answer as many of them as we can about the trial. So I'm going to send this next question to you, Bob Bianchi, about the co-defendant, the co-conspirator in this case, who's also facing criminal charges, Cortland Henry, known as YNW Bortland. He was the driver of the vehicle that night. This is One Icy Woo from Instagram. They ask, will the state prosecute Cortland Henry as the murderer if MELLY is innocent? And I'm wondering if the question is being asked because will they try to say he was the trigger man, not just the driver, if MELLY is acquitted?
Yeah, that's a really, really interesting question, and it's a prosecutorial discretion question. I have literally been involved in cases where the principal is found not guilty, but prosecutors continue to prosecute the person that they believe was involved in the conspiracy. Essentially, what the prosecutor feels is that the acquittal was not appropriate, that they had enough evidence, and if they think somebody else was an aider and abetter or a conspirator, they can still prosecute that individual. So that's really up to the prosecutors at the end of the day to say to themselves, ultimately, though, hey, if we couldn't prove that he was the shooter and he was acquitted, do we want to really go forward with somebody else who's not a shooter but a co-conspirator? Again, a prosecutorial decision. I will say there are times, Anjanette, where prosecutors say, you know what? I'd rather try the case. I know it's going to be tough. I believe he did it. If he's acquitted, but at least we gave it the fair fight.
Yeah, that's all they can do at some points in time, you know? Like, if they think they've got the evidence and they think the person did it, they have to go forward, and they roll the dice. TikTok, this question is from TikTok. It's from Lay from TikTok. Why isn't Bortland getting the same treatment as MELLY if most of the evidence is on Bortland? And I think this question, Terry, it relates to the fact that MELLY is facing the possibility of the death penalty. YNW Bortland is not.
Well, that's right. And, you know, the death penalty obviously is a final sentence. I mean, it'll be appealed if, in fact, he's convicted and he gets that. But I think that right now, because the case is severed, they will be pointing the finger at each other. You heard in the opening for the defense that they were saying, look, it wasn't MELLY who was lying. It was Henry who was lying. So they're basically trying to say, look, it was Henry who said that he was the only one in the car. My person has not done any of that. So I think having it severed is better for each of the defendants, frankly, because sitting at the same table, they can't really do much of the accusatory actions that they're doing now. And right now, we can't see any defense, obviously, from Henry because he's not here. But when that trial takes place, you better believe that they will probably be pointing the finger the other way. So because it's severed, I think it's easier for each of those defendants to be able to point to each other.
Yeah, a lot of this going on in this case because they can do it. As you mentioned, the cases are severed. Let's go to the next question. I'll send this one to you, Brian Bruckmeyer. Extra_simply from Instagram asks, why did he leave his one friend to take the others to the hospital? And I think this question refers to Bortland taking off with the vehicle and MELLY not going to the hospital as well.
Yeah, I mean, we're only going to know if he takes the stand and testifies, but I guess the assumption for the prosecutor would be is that YNW MELLY is the main guy. He's the trigger guy. I mean, that's why they're asking for the death penalty for him rather than that of Cortland Henry. He's only looking at life in prison. But I'm assuming they would say that YNW MELLY didn't want to be associated with the lie, the conspiracy, the cover-up, that this was supposedly a drive-by, that he and Henry must have concocted this idea beforehand, and MELLY would stay back and Henry would go and drop off. Now, the curious question becomes is, if they fail in this case, do they still proceed to Henry, as Bob was talking about? I don't think that they'll be able to say that Henry was the trigger man. Of course, in this trial, the defense can argue Henry was the trigger man. We don't know if our guy was the trigger man. The angles and the trajectory, we don't know if those are correct. But a prosecutor has to stick to the same theory. Otherwise, if they flip-flop, it is a defense attorney's dream. Oh my gosh, you thought this guy was a shooter this day, you thought this guy was a shooter the next day. Your theories keep jumping back and forth wherever you win or lose. I think there's a lot to gain here for the defense, not so much for the prosecution until they tie up some loose ends.
Bob Bianchi, I'm going to send this next question to you. As a former elected prosecutor, county prosecutor, Joni Smith from YouTube asks, if you were the prosecutor, would you be happy with the way this has gone so far? I think that's a great question.
Well, you know, fortunately for me, I was not elected. I was appointed by the governor to that position. That's
pardon me.
No. That's how we do it in Jersey. And I say this for a reason. I make that distinction for a reason. When I'm appointed, I don't have to worry about the court of public opinion. I don't have to worry about being elected again. I don't have to worry about raising money. to answer the direct question about whether I would be happy about the way the prosecution is going, I'm not happy about the expert witness that was attacked and the defense scored points. I'm extremely unhappy that my assistant prosecutor did something in violation of a court order that could jeopardize the case, even if not now, but certainly for appeal. So listen, sometimes to answer the viewer's question, you dance with the one you brought. I've tried lots of cases that the evidence wasn't so good. There were nefarious witnesses we had to put on the stand. Things started to fall apart, but we were convinced the person did it. That's my ethical obligation. And so then I would just say to my staff, or I would say to myself, you're going to go in and fight the fair fight, and whatever the jury does, the jury does. But to answer directly, I am not happy about the way the prosecution has put this case in, nor the witnesses who have testified.
And Anjanette, on
Very
the other side,
interesting.
the defense attorney probably had a very good long weekend. They were probably dancing most of that weekend.
Sure.
Yeah, I think that they are happy with where things sit right now. I mean, they were pretty upset at the end of the day on Thursday. Probably don't like that their mistrial motions were denied, but I mean, they've been able to do a really good job on cross with a lot of these witnesses, it seems, from where I'm sitting. Our next question, Neosha from YouTube, Terry. Why didn't they put his girlfriend on the stand? That's Mariah Hamilton. We heard from Mariah's mom, Felicia Holmes, on Thursday, but do you think we'll end up hearing from the girlfriend?
I think that's a great question, and it is a distinct possibility. I think that on the stand, the mother was really afraid. She basically said on the stand, the very first thing she said when she sat down was, I'm intimidated, I'm afraid. And ultimately, she explained that she was afraid of the prosecutor, and specifically, she was afraid of Bradley. And I think, obviously, it's because she feels as though both she and her daughter have some exposure here. She was under arrest. She was wearing an ankle bracelet. She said she lost her job. And so I think both of them are in fear of getting up on that stand. We saw Felicia first. I do think we may see Mariah second. Obviously, she was accused of perhaps being an accessory after the fact, and so she is frightened. But I think to answer the viewer's direct question, there's a possibility she could be called.
And Felicia Holmes said that on Thursday, Terry, that she, her daughter that was threatened by the police, according to her, with being charged as an accessory after the fact, because it sounded like back in 2018 they may not have been talking. Let's go next to Freckly Facey from Instagram, Brian. Why are they bothered by Melly's actions in the courthouse when in a situation of facing the death penalty, you have no choice but to try to stay positive? And we've seen Melly be pretty expressive in the courtroom.
Yeah, I would agree. I've done trials that I've had clients next to me who have seen a trial go well. In the middle of it, they're smiling, or a trial go poorly. In the middle of it, they kind of frown. The thing that I agree with you. It should be that he's allowed to go through this process however he wants. The problem is he is literally being judged. Every action, whether it be a smile, a frown, he wears a brown jacket, he wears a cream jacket, an entire state has said that you are accused of the highest crime and they are seeking the highest punishment. And so just to be safe and try to please as many people as possible, there is a reverence that most defendants are asked to have, so that people, when judging them, will judge them positively rather than negatively, as so many people are. I've never been on trial where my life is on the line. I don't know how I would act. I don't know what his mental status is. I don't know how he reacts to stress, but people are people.
That's for sure. People are people. And, Bernardo Villolona and I were talking about this the other day, that we don't know his mental health condition, his mental health state, and people do react to things differently, and he is under a lot of pressure. All right, guys, keep your questions coming to us on YouTube, Twitter, Facebook, Instagram, and TikTok. We'll get to as many of them as we can, but for now, we're going to take a quick break. I'm Anjanette Levy, and you are watching the Q&A Lunch Show on Law and Crime.
If you're tired of spending a ton on all your streaming services, then welcome to Philo. Say goodbye to cable boxes, contracts, and endless searches for something to watch, and hello to more than 70 channels and thousands of movies for just $25 a month. Your favorite networks and shows live and on demand, plus an unlimited DVR to save them all? Philo's got you covered. With the free 7-day trial, you can sit back, relax, and save hundreds. Visit philo.tv to start streaming and find out why people who love TV love Philo.
Thanks for joining us here on Law and Crime. I'm Anjanette Levy, and we are taking your questions this hour on the case of YNW MELLY. That trial is well underway in Broward County, Florida. And MELLY is a rapper accused of murdering two of his friends, YNW Juvie, YNW Sack Chaser, back in October of 2018. MELLY says he didn't do it. He also has a co-defendant, Cortland Henry, who goes by YNW Bortland, who faces charges in this case as well, but will be tried separately at a later date. We're taking your questions, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, and TikTok, and we'll get to as many of them as we can. Bob Bianchi is here with me, Brian Buckmeyer, Terry Austin. We're all Law and Crime all the time here today. Bob, I'm going to send this next question to you. It comes from Wesley Passmore from YouTube. And Wesley asks, do you think the mistrial not happening is in favor of YNW MELLY, and how do you think his mannerisms in court will affect the jury's decision?
I'll take the last one first, and by the way, great questions. His mannerisms are not helping him in the courtroom. You just don't need the jurors to feel that those weird things he's doing are disrespectful to the court, because they're going to make an analogy, and maybe as a prosecutor I want to sum up, if this is the way he takes it as a joke or whatever you hear, can you imagine what he's capable of doing outside of the courtroom? So I'll just leave that aside. As a defense lawyer, you just don't need that. With respect to the mistrial motion, great question. There's a lot of nuance here. Let's get to it. On the motion for a mistrial, what I had imagined the defense would have done, and Brian can see if he can confirm, and each state's a little bit different, is that the judge were to have granted it, the defense would have then indicated that they want to have the case dismissed for double jeopardy grounds. They would have argued that this mistrial was done because of purposeful, outrageous conduct by prosecutors, and that he should not be convicted or brought to trial a second time. Now, that's a really hard standard in most instances, but what the defense attorney clearly wants to do is create a record for appeal, and if the judge denies all these things, an appellate court can revisit it. But Anjanette, here is the tactical issue here. When you have a really good case and your case is going well, a lot of times you make these motions because you have to preserve the record, hoping the judge denies the motion, because if the judge were to say mistrial, but I'm not granting double jeopardy, so we go back to square one, the defense can't guarantee on the second act or the second play that the testimony is going to be as good because they've already let their cards out to a certain extent. So a lot of times you want to win the battle by losing, or win the war by losing that battle. So it's a really sophisticated and nuanced thing here. But the judge actually did them a favor. The judges often say, you know what, I'm not granting a mistrial. Now you prosecutors have created an appellate issue in this case. Now I'm going to give a curative instruction to this jury to say what you did was wrong and that they should disregard it. And then the defense lawyers can say, whew, wow, now we don't have to have another trial from the beginning when our trial's going in so well right now.
Good insight from you, Bob Bianchi. I'm going to send this next question to you, Terry Austin. It's from Slap Shoddy from TikTok. What if Melly gets the death penalty and later on we find out it wasn't him?
Well, that's a good question. I mean, that's part of the issue many people have with the death penalty. There is no room for any sort of mistake. And there is a distinct possibility that if convicted, he could get the death penalty because we know that the Governor DeSantis just signed a new law that says it doesn't have to be unanimous 12-0. It can be 8-4. And so it is a bigger possibility that that death sentence could be issued here. So if it's the wrong answer, and ultimately some of the other people that the defense pointed to who said might have been suspects in this case, but that the prosecution didn't go after them, if we find out later that someone else did it, or perhaps that, you know, Henry did it and Melly didn't do it, whatever the scenario is, if you find something out later, it is too late if in fact that death sentence has been issued and executed. Now, I will say that it does take years because oftentimes there are appeals, as there should be, because it's a very final sentence. So hopefully, you know, if it gets to that point, it's the right conclusion, but that is in fact a very serious problem with the death penalty. You have to be absolutely correct.
Yeah, definitely. And, you know, a lot of people have a lot of questions about that lower threshold now for that law that Governor DeSantis just signed back in April. So this is just a recent thing that's happened. We'll send this question to you, Brian Buckmeyer. Horatio27 from TikTok asks, do you think the prosecutor will bring up prior bad acts such as the shooting that happened?
So there should have been a ruling on it already as to whether or not it came in. The only other thing the prosecutor could do is try to question a witness in a way that opens the door. Or maybe if the defense puts on someone on the stand, this might actually be a reason why YNW and Melly doesn't testify. Not necessarily because of anything that happened in this case or this incident, but because of prior bad acts. If he goes up there and says, I never touched a gun, I've never touched a gun in my life, then they get to attack that second half of it and say, hey, here are other cases, here are other videos, here are other photos of you showing the gun, and that prejudice could come in based on his own words. So do I think the prior bad acts will come in? At this point, I think if there's a ruling on it, no. However, testimony in the future, whether it be YNW Melly himself or other witnesses, could potentially open the door to it.
Let's go to our next question for Bob Bianchi. This is from @LegendDad2013 from Twitter. Why are they charging Melly with 2 first-degree murders when the other person in the car, Bortland, could have pulled the trigger?
Well, that kind of gets back to what Terry was talking about before. Listen, having tried death penalty cases, the #1 rule is you have to be absolutely convinced at who the person is that shot the individual. You can't have any hesitation about that. There could be no other explanation. So you also have to have aggravating factors in a case in order to get the death penalty. In this particular case, I think the aggravating factors against Melly are very weak to begin with, and they're certainly going to be weaker to the co-defendants or even aiders or abettors with regard to whether those aggravating factors exist sufficient enough to justify the imposition of the death penalty. So a shooter you get, the people that may have been surrounding them don't implicate the same aggravating factors as the shooter. So this is why, if there is any dispute in a prosecutor's mind as who the person was that potentially killed the person, it should not be a death penalty case. And if you are not surely convinced that you can prove beyond a reasonable doubt to each and every individual juror each aggravating factor, at least one aggravating factor that justifies the death penalty beyond a reasonable doubt, then you should not be imposing it. We have a lower standard now with the DeSantis rule, if you will, but as a prosecutor that's tried death penalty cases for the life of me, I don't even understand why this is a death penalty case to begin with. I'm not suggesting that what happened is right, but you have to make a decision as to whether the aggravating factors in the case, for example, vulnerability of individuals, young people, old people, was it done, in the commission of a felony is certainly one of them. Was it done as part of terrorism? There's a number of aggravating factors. Are they sufficient enough to go in that direction where you're asking the jury to give the ultimate penalty, and especially in a case where the defense seems to be showing to a jury, he may not have even been the shooter. It's not a good death penalty case.
Well, the state says he was the shooter because they have this surveillance video of him getting into the back passenger or back driver's side seat. And so they're saying that these, bullets were fired from there. They're stippling on the victims, meaning at close range that these happened. There's another question, Terry, I'm going to send to you from Georgia Peach, I think, GA Peach 1988 from Twitter. And this is kind of tough because we heard this testimony last week, but I think it's kind of, confusing to people. Can you explain the trajectory of the bullets in reference to the angle of the bullets in the car?
Well, it's interesting because during the opening for the prosecution, she actually did state, listen, don't forget your science that you learned when you were in school. And she admitted it's not going to be foolproof, that all of her evidence that she's putting in from a forensic standpoint might not tell you the exact thing that happened. And in fact, when she brought those forensics in and she questioned them, they could not basically state certainly that the trajectory was from that back seat. And here's the reason why. We heard on cross-examination, and I mentioned this before, that we don't know so many of the variables. We don't know how high or how tall the individual was. We don't know where he or she was sitting. We don't know any of the information which could actually give us the trajectory of those bullets. And so they actually had to admit on the stand during cross-examination that essentially it was a guesstimate. So I think it's a very difficult issue. I think that that's a weakness in the prosecution's case, and I think if they can't definitively state how those bullets were shot from that back seat, it's really going to be very difficult to put MELLY in the box. And that's what they've done right now. I think Bob is absolutely right. They've said, look, MELLY was the one with the gun. MELLY was the one who shot. He was in the back. You have that, gunshot on close range. And so for those reasons, they decided that he was the one who was the shooter. But it's not that definitive, at least not in my mind, and I think in the minds of those jurors as well.
Mm-hmm. Well, it'll be interesting. Terry, I want to see what you say later in the day about how this jury looks as they're listening to the testimony. I know it's hard to read them, but sometimes they're kind of expressive and you can tell what they're thinking. But we still have a long way to go. And we are going to take a quick break. So stay with us and keep your questions coming to us on YouTube, Instagram, TikTok, Twitter, Facebook, and we'll get to as many of them as we can. I'm Anjanette Levy, and you're watching Law and Crime. We'll be right back.
Busy schedules, changing times, competing priorities. None of these should get in the way of your education. University of Memphis Global offers nationally ranked online programs, dedicated full-time faculty, and more than 20 years of experience. Be a Memphis Tiger, wherever you are. Earn your degree at University of Memphis Global, one of the top online bachelor's degree programs in the country.
To learn more, visit uofmglobal.memphis.edu.
Okay, welcome back to Law and Crime Network. My name is Bob Bianchi. I'll be taking it for the next 2 hours. Our trial coverage takes us to Broward County, Florida, for the trial of Jamel Demons, better known by his stage name YNW MELLY. The South Florida rapper is charged with 2 counts of first-degree murder for the deaths of his 2 friends, Christopher Thomas Jr. and Anthony Williams, who are also part of the YNW collaborative, along with Cortland Henry. The co-defendant in this case will be tried separately, those cases having been severed. Today, court is off to a late start because of a juror issue, and we're going to recap some of the key moments from Thursday's testimony due to the court being dark on Friday and Monday. And as soon as court starts, of course, you know we're going to jump right into it. So let's listen to the testimony of forensic scientist Tara Shell.
And without getting into the actual results, we're just going to orient the jury to the chart that I have here, beginning with the top left.
Yes, so the top left is an image kind of showing where the particle is located on the sample, and that is taken at 400 times magnification.
And the top right?
That is now a closer up image of that particle taken at 3200 times magnification, where you can see clearly that it is bright, it is round in shape, and you kind of are able to visualize really the morphology of that particle.
And bottom left?
So that is what is called the EDS spectrum. Basically, it's just showing you what elements are present in that particle. So PB is lead, BA is barium, and SB is antimony. So you see peaks for all of those present in that particle. Therefore, it is a particle that contains lead, barium, and antimony, which makes it characteristic of gunshot residue.
And are the peaks that we see consistent with the amount of that compound within the sample?
Yes, overall, the height of the peaks relates to how much of that element is in the particle.
And finally, the bottom right.
So that is the image that the instrument takes during the automated analysis.
I'm showing you what's been entered into evidence in states 57. Do you recognize that?
I do, yes.
And what is that?
This is a gunshot residue kit that we received in this case.
Okay. And did you analyze states 57?
Yes, I did.
And did you ultimately analyze state 60?
Yes, I did.
Okay. So, let me grab your scissors. Go ahead and open states 57. And I'm going to ask permission from the judge for you to step down.
Okay.
You may. You want to open it, grab some gloves, and we'll
Okay.
go to the machine.
Just if you can publish states 57.
And the contents. So you received one sample, but there are 2 tubes.
Yes.
What are they representative of?
These were samples that we had received that are labeled as coming from the right hand and the left hand.
And who's the individual?
Cortland Henry.
Did you ultimately have a chance to analyze and go through this SEM process, which was the automated process, and your individual process, in order to come up with an opinion as to the presence of GSR?
Yes.
And what was that opinion? And if you can specify both the left and then the right.
So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and 2 two-component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 two-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay. And what affects the presence or absence of GSR on a person's hand or any object?
Sure. So if there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
Okay. And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results of Cortland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or three compounds that you were looking for, and which compounds were present in Cortland Henry's left hand?
Lead, barium, and antimony were present in that particle.
So all three components.
Yes.
Okay, and let's move on to stage 60, which was the sample for the G. What were your results? And again, did you also go through the SEM automated process and then your individual characteristic process?
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 2-component particles.
Okay, and what does that mean?
So, like I mentioned, 2-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with 2-component particles, or any of the particles we look at, if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of 2-component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
Are you familiar with them in general?
I am, yes.
Are you familiar with the friend or foe presumptive GSR kit?
I am.
What is that kit testing?
That kit is like you said, a presumptive test that is looking for the presence of nitrates, so nitrogen containing compounds.
Okay. So for instance, these GSR kits are made to essentially alert to the presence of a certain compound.
Yes.
And the friend or foe kit specifically alerts to the compound of nitrogen particles.
Yes.
So the presence or absence of nitrogen particles.
Correct.
And are presumptive tests relied on exclusively?
No, they are just a screening tool. Like I mentioned, they're looking for nitrates, and there are many things that can contain nitrates. So they are not conclusive to the presence of gunshot residue or gunpowder. They are really just to be used as a screening tool.
Okay, well, welcome back. I still have Brian Buckmeyer in studio with me. You know, what can I say? He's just everything extraordinaire at the Law and Crime Network. So it's great to have my friend here as well. It's Natalie Whittingham-Burrell, who is a criminal defense lawyer. And I'm being told, I'm looking at the producer says here, known as, this is what I'm being told you're known as. This is not what I am saying. Let's be clear for the record here, that you are referred to as the lawyer chick on YouTube. Is that right? Is that what you refer to yourself as?
Yes, so I will not be offended. Here on YouTube, I am known as Natalie Lawyer Chick.
Yeah, I don't want to step into anything here, but anyway, that's great for you because I hear that you're awesome, and I'm glad that you're here on the show. Natalie, let's look. This testimony as a prosecutor, still to this day, all these years later, makes me want to faint. I get nervous. You have to put it in. It's important to the case. You don't want to lose the jury. So rather than talk about the ins and outs of the perfunctory part of admitting your evidence in, which is a skill set you have to learn as a prosecutor, what are your thoughts about the trial overall, where it's going? What are you seeing?
Well, from the perspective of a defense attorney, I know that jurors treat forensic evidence very, very seriously, and the presence or lack of it can be detrimental to a prosecutor's case. That does not mean that a state cannot win their case without that forensic evidence. And here, they just don't have the forensic evidence to back up their case. What they have is YNW Melly in the back seat, even according to his girlfriend's mother, and phone records placing him there when the shooting is alleged to have occurred. That's their best evidence. But this gunshot residue being found on YNW Bortland's hands is more helpful to YNW Melly than it isn't. The same thing with the ballistics evidence. It was more helpful to YNW Melly than it was not helpful to him.
Wow, a great point, Brian. We were talking with Ann Jeanette before, and I want to get into this because I think it's so important. They're talking about the motive, and I hate when, and it's true, the prosecution does not have to prove motive, but you sure want it as a prosecutor, and a defense attorney is sure going to say, what would cause him to do this? Now, we're talking about aggravating factors, Brian. We talked about it before, and I heard that there's a dispute. It could be, maybe it was over a financial thing, assuming you want to believe the state's theory of the case. Maybe it's gang related. First of all, where, Brian, is the evidence of the gang related aspect of it? Is just another wild throw it out there? Because this is really important, because the gang relation is one of the aggravating factors for the death penalty case, Brian.
Yeah, so first and foremost, understand when I answer these questions what I am. I'm a former public defender from Brooklyn, not from Brooklyn, but practice in Brooklyn. And so what I see oftentimes in cases like this, unless you're going to get that smoking gun of my client's in a gang and watch him do gang stuff and look at this video of him acknowledging that he's in a gang, they're just gonna throw circumstance and the typical tropes. Look at his face. He has tattoos. Look at the way he raps. Look at the way he holds himself. Clearly he must be in a gang. But there's no, unlike what my grandfather, my mom probably says, guilt by association. You have to actually participate in the gang. You can't just go on a social media or go on a rap video and say, hey, I'm a part of this crew, or hey, I'm a part of this crew. Hey, you can even be part of that crew, but if you're not doing anything gang related, the enhancement doesn't seem to work there. And here we have a case where no one's quite sure what it is. Is it money motivated? Is it gang motivated? Maybe he is in a gang, but this was his day off. I don't know. But I don't know, I guess they get days off. We get days off as attorneys. I assume you get days off on gangs. You can't be gang banging every day. But if there's no evidence and there's just this pomp and circumstance of, look at his face, look at his tattoos, he says he is a gang, this must be gang related because someone died around him, I don't see the aggravating circumstances.
Yeah, and Natalie, I go to the point, and I think that this is not a liberal concept. This is from a person who's tried death penalty cases as a prosecutor. I want to be absolutely convinced who the shooter is in a case like this, and I want to be absolutely convinced as to what the motive is, because with all respect to the judges and the defense lawyers and the prosecutors, the system is not infallible, and I think in the end as a prosecutor, tactically, the defense is going to jam this down the prosecutor's throat in summation to say they're just throwing the spaghetti against the wall and hoping something sticks, and then they ask you to convict him of capital murder for that? I mean, you talk to me. What are your thoughts as a defense lawyer? Because this is one where I think they could really get outraged about.
Yeah, as a defense lawyer, I always anticipate where the state doesn't have a motive. And I know that in closing, the state's going to hammer home that they don't even have to prove a motive in order to prove their case. But we know juries and we know real life people, and they're going to want to know why. Why did this happen? And so far, there's been no evidence of a why. If you believe that YNW Melly is in a gang, then you must also believe that YNW Sack Chaser and the other gentlemen were also in the same gang. What type of conflict was there in order for this alleged murder or hit to be ordered or carried out by YNW Melly? There's just no evidence of it so far. And as you said, in a death penalty case, the jury's really going to want to see the proof.
Yeah, and I'll tell you what, it's not just so much showing what the motive is, i.e. if they want to prove it's gangs, it's just show it's not any other motive. At least that's what I would do as a prosecutor. Anyway, now let's take a listen to the cross-examination and a bit of the redirect.
You got the sample from Marijuana Police Department?
Yes.
Specifically, Detective Moretti directed to you?
Yes.
And when we talk about GSR, or gunshot residue. You're aware that GSR can be found on clothes, right?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection calls for speculation outside the scope of the law.
Well, I don't know that calls for speculation. If she knows she can answer the question, overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
In your examination, had you received clothes, you could test those clothes for GSR, correct?
Yes, we can certainly test clothing.
And you've done that many times, correct?
Yes, absolutely.
Also, if someone is in a hospital, in a bed in a hospital, do you know if that person has washed their hands?
I don't.
Okay. And by washing your hands, you can get rid of GSR, correct?
Yes, hand washing can remove most, if not all, of the particles on someone's hands.
Do you know if Cortland Henry washed his hands or changed his clothes?
I don't know that.
Is hand washing the only thing, contrary to popular belief, that removes gunshot residue?
No, gunshot residue is easily removed in general. So with respect to the hands, any type of activity, touching or use of the hands can remove particles pretty easily. With clothing, any activity. So if the garment is touching things, if it's laundered.
If it's removed?
Yes, any activity can cause particles to be disrupted or removed.
And you're an independent lab, correct?
Yes, we are.
You're not associated with Miramar Police Department?
Correct, we are not.
You're not associated with the Broward Sheriff's Office?
We are not.
So you can only test what you're submitted, correct?
Correct.
Nothing further.
One question. If I may. You were hired by the Miramar Police Department to perform this test then, correct?
Yes, they're the ones that submitted the samples.
You can only test what was submitted. On that note, we're going to take a break. We'll talk about it on the other end. Please stay with us. Turns out to be why, and we're completely thrown off in the beginning of the case. But I have a moral responsibility when I get in there that I know, no matter how hard the evidence is, that this is the person who did it, and we have done everything to check to see if it was anyone else, and to build up that case so that all threads were tied up, if for no other reason that you don't have what the defense attorney did right here with this forensic expert to show that you were malfeasance. The more malfeasance there is, the less confidence the jury has. What are your thoughts?
So exactly right. And as the defense attorney, I'm looking for every single opening that you're going to give me. And there were a lot of openings here in the forensic evidence. There were even openings with their civilian witness, the mother of the girlfriend. There were openings all over the place, and YNW MELLY's attorneys are highly skilled. And so they got right into those openings and pointed out all of the inconsistencies, all of the ways in which the evidence is missing and lacking. And that was only cross-examination. Wait until they get to closing arguments and they're able to point out every single opening that was left by the state. All of those openings are reasonable doubt. At least that will be the defense's argument. Does that get them over the finish lines to not guilty or a hung verdict? I don't know, but I do know that it seems like the prosecution left a lot to be desired here so far.
Well, you definitely know things. My producer said you were rather prescient, and in fact, during the course of your answer, you proved that because Felicia Holmes, the mother of the defendant's ex-girlfriend, which you just mentioned, took the stand on Thursday, and there was never a dull moment for sure. Let's take a listen as to why.
Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamel Simmons, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it may be 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Simmons?
Yes, I did.
What did you refer to him as?
I call him Jamel Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your Honor, may the record reflect an in-court identification of the defendant?
Yes, the record will reflect an in-court identification of the defendant.
So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I do.
And who is she?
Jamie.
Had you met her prior to October 26th of 2018?
Yes, I did.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you, sir.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or a FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot in that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Because 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter and take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection has been answered. Excuse me. Overruled.
Ms. Holmes, did you ever say the defendant made you quit your job?
I never really said anything like that. I know what's ever made me quit my job.
Objection. Overruled.
If I may approach him? I'm going to show you this next few minutes. Okay. So, Ms. Holmes, I'm going to ask you again. Have you ever made a statement that the defendant made you quit your job and that they would take care of us until the trial was over?
I never really say anything like that.
Okay. So you're denying making that statement?
I never really say anything like that.
No.
Objection.
Your Honor, can I just have a standing objection so we don't keep interrupting?
Thank you. Stay with your heard on the standing objection.
Whatever defense it
That's
chooses
fine.
to
Go
proceed.
ahead.
Okay. So, Ms. Holmes, in terms of have you ever said a statement, have you ever made a statement to the effect of you were told to quit your job and the defense would take care of us?
Of the judge? No.
Excuse me.
The defense? No.
How much comes out?
Let me let Ms. Holmes ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about what happened.
Did she tell you what happened? Without? No, she didn't.
Just told she didn't know.
Have you ever made a statement that is different than that?
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Man, I don't know who's more angry, the witness or the defense attorney on that one, but we're going to talk about it with our awesome guests on the other end. Take a break. Please stay with us.
We did get an update from the juror who was in a hospital this morning, and my understanding is she will be joining us. Everything was just, I guess, issue of dehydration or something along those lines, but I'm told she will be here. Can you hear me all right? All right. One thing, though, I need to bring to your attention is when we broke this morning, one of our jurors, as Gary was escorting the jurors out, he was approached, and one of the jurors had asked him a question. Gary, go ahead. You want to tell us exactly what was said by whom?
She more or less asked me if she could ask me a question. I said, well, it depends. So the question was, she said, well, what's the status of the mistrial?
So now, I don't know what you want me to do about that, but that's the question that was posed.
Judge, we need to have her record and find out how she would have any knowledge of that, because that was never stated in front of them.
I think it was. I think there was it was done on the record by Mr. Howard the other day. Is Mr. Howard here? No?
No, he's not.
Oh, I apologize. I thought we were all here.
He's coming right now, Joe.
Mr. Howard, I'm sorry.
Oh, no problem with it. I heard it all inside the media room. So, no apology necessary. Thank you. Apologize for not being present.
No, it's my
Can't see
fault.
me.
I thought Gary walked in, but what he was advising me and I to the attorneys was that there was a comment by one of the jurors. Did you hear that?
Yes.
So I don't know exactly what you want me to do. Who the juror was?
That was Miss Manuel.
Miss Manuel. So I guess one of the things that is, my recollection, and I could be wrong, is different than yours, Ms. Bradley. My recollection is that there was a motion for mistrial that was made out loud, and Mr. Howard came sidebar. But the jurors have been instructed not to read anything about the case. So I don't know if there's something in the newspaper about that. That's a different story, but I don't know what you want me to do, if anything. I bring it to your attention, any real interaction that Gary has with them, something that may seem inappropriate, we always bring it up and let you know.
And should I assume that for future reference, you'd rather I make those motions outside the presence of the jury?
Just come sign.
Okay.
But that was my recollection. I thought you, at one point, I don't know which, there was two motions for mistrial. I don't know at which point, but I believe at least one point you stood up and said, I have a motion for mistrial.
No, actually, there was a question asked. I said objection, move for mistrial. And
No,
you called the
before.
sidebar and asked me to hold it until the end. And then at the end, after the jury left, Mr. Adelstein and I articulated motions for mistrial on an independent basis. And that's how it trended. That's how it went down.
But it was announced in open court, correct?
I said objection, move for mistrial. You called
That's
the
my
sidebar.
recollection.
I remember coming sidebar and that being said in sidebar. I don't recall it being said in open court.
I thought it was said in open court.
It's a fact that I said it.
So again, I don't know what you want me to do, if anything, and, the jurors, is that juror here, by the way?
She's in the reception area.
So, anyway, I'll leave it to your discretion. It was announced in open court, there was a motion for mistrial. Gary obviously didn't answer the question. And, what did you respond, Gary?
I told her I didn't know anything about that. And then she asked me, weren't you there? I said, I don't remember that.
Anyway, that's where we're at. So, you think it over. Let me know if there's any inquiry you want me to make. Madam? Same
Yeah, I
for both
think
of
you need to, the state's position would be that she needs to be brought in. Your Honor needs to inquire if she's seen anything in the media or any coverage of that, because that was discussed online, is my understanding.
What do you think, counsel?
Well, to the extent that the court's inquiry of this jury is because of the state's faulty recollection that I didn't say move for mistrial in front of the jury, I know that not to be the case. I did say objection, move for mistrial. You then called a sidebar, and the only thing you said was, please reserve that to me.
That's my recollection.
Yeah, that's what I.
Again, is that what you're concerned about, or is it concerned about just because it was said that you think I ought to inquire?
Your Honor, I think that it's at defense's peril if we go forward, and if they're going to waive any inquiry of this witness, if she's been looking at any of the other items or anything online that defense brought to Your Honor's attention earlier. Because if they thought was laboring under the impression that there was some sort of cessation of trial and then started looking at media and news reports because they thought their jury service was over, that would be a problem.
Better to have more information than less, so we have no objection to that being the procedure that we employ.
So you want me to bring her in, indicate to her that I was advised by our bailiff, Gary, that you had asked him about a motion for mistrial and what had happened, and just ask her, how is it that you're you're concerned about that, or where did you hear about it? And just find out what information she's got and about it and where she heard it from. Is that the end of the inquiry?
I would ask that you inquire from her if she conveyed any of that to any of the other jurors.
Anything else?
Unless the court wants to say, unfortunately, I denied that.
So we're going to ask what she heard, where she learned it from.
If she did any outside research afterwards.
And if she inquired or asked any of the other jurors concerning that topic.
Anything else that you want me to ask, counsel? Ben?
Anything else, David?
Nothing, sir.
All right. Do me a favor.
You went together.
Okay. I don't like it either.
Just for Gary. Yeah.
Thank you. Ms. Manuel's coming in, counsel.
Pardon?
Ms. Manuel's going to come in now.
Okay. Thank you.
Yours, Zachary?
Hey, Ms. Manuel, thanks for coming back in. Let the record reflect the approach of the defendant, his counsel, the assistant state attorneys, as well as one of our jurors, Ms. Manuel. Counsel, please be seated. Ms. Manuel, please be seated. Ms. Manuel, why I brought in is my bailiff indicated to me that when you weren't able to start this morning, that he was escorting the jurors out, and you approached him and asked him about what happened with the mistrial or something to this effect. Is that right? So that's a yes. All right. So I guess my concern is what you may have heard about this alleged mistrial and where you heard it from.
The last day I was here, and the defense attorney jumped up and said mistrial.
Okay. So that's where you heard it from?
Yes.
Anything other than that?
No.
Was there any other research that you may have done or looked at newspapers or any kind of article about the motion for mistrial, anything like that?
No.
Anything on the news, any news media
No.
about a mistrial? No. And last but not least, did you speak with any of the other jurors about the motion for mistrial?
No, when Gary came in and asked us this morning, do we have any issues, any questions? And I didn't want to ask him in front of everybody, so I waited till we got in the hall and I put him to the side and asked him that. If he asked me, we have any concerns.
Okay. All right.
Time to elevate your game. At Tennis Point, we've got you covered. With the latest and greatest gear in the market, it's a one-stop shop. Visit tennis-point.com today.
Thank you. Let the record reflect the juror stepped out. Counsel remain will defend. Anything you wish to do regarding this issue with Ms. Manuel?
No, sir.
So are we otherwise ready to proceed?
Yes. Juror shows up, yes.
I think, are they all here?
As far as I know, no.
Okay, so see if they're all here. If they're all here, we'll start. Yeah, he did say we're short 2 or 3. 3. But they're here now?
They're all here.
All right, they're all here now. You all ready?
Go.
Okay, counsel, I'll bring you in. Is that all right?
Yes, sir.
All right, let's bring the jury in. Thanks, Tom.
Jury entering.
Please be seated. Let the record once again reflect the presence of the defendant. his counsel, the assistant state attorneys, and as well as the ladies and gentlemen of the jury. Ladies and gentlemen, sorry for the late start. Hopefully everybody's all right. We appreciate your patience. We also appreciate the fact that you're all here, and we thank you. But we're ready to begin again. When we left off last week, the state was still on its case in chief. Madam, who's your next witness?
Susan Johnson of T-Mobile.
Susan Johnson, please.
Good afternoon. Are you Susan Johnson?
Yes, sir.
Welcome.
Thank you.
What I'd like to do is raise your right hand for us.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Susan Johnson,
Please spell your first and last name for the court reporter.
SUSAN, JOHNSON.
Please have a seat.
Thank you.
Ms. Johnson, that microphone in front of you will adjust up or down, but not back and forth. Okay?
Thank you.
Are you ready to proceed, ma'am?
Yes, sir.
Counsel, you may.
Thank you. Good afternoon, Ms. Johnson. How are you today?
Good, thank you.
Could you please introduce yourself to the ladies and gentlemen of the jury and tell them where you work?
Sure. My name is Susan Johnson, and I work for T-Mobile.
How long have you worked for T-Mobile?
A total of 26 years.
And what do you do for T-Mobile?
I am a manager within the legal emergency response unit.
Prior to working for T-Mobile, did you work for any other telecommunications companies?
Yes, I did.
And what were those?
AT&T Wireless.
And how long did you work for AT&T?
5 years.
How long in total have you worked in the telecommunications industry?
31 years.
So you indicated you were part of the manager of the emergency response.
Legal emergency response.
And what does that mean?
That means that we respond to subpoenas and other legal demands from various agencies across the United States.
And when you say a legal demand, what would you mean by that?
Subpoena or a court order, search warrant.
In terms of the records when you work with them, how often do you work with them?
Every day.
What do you do with the records?
So we're able to retrieve the information from our secured computer database and then send the response back to the agency that's requesting.
And I know this might sound silly, but what type of company is T-Mobile?
We're a wireless telephone carrier.
And is T-Mobile the parent company of any other wireless carriers?
We did acquire Sprint.
How long has T-Mobile been the parent company for Sprint?
April 1st, 2020 is when we acquired them.
In terms of the information that is kept by T-Mobile, do you keep phone call records?
Yes.
What would you call those?
Call detail records.
Do you keep information regarding the networks?
Yes.
Do you keep information regarding subscribers?
Yes.
What type of information is kept in a call detail record?
So call detail reports will show incoming and outgoing phone calls or text messages made or received by the cellular telephone.
Does T-Mobile keep that information as to when data is used?
Yes.
Will a data phone call or video call show up in call detail records?
No.
Does the information show for who is being called?
Yes, it will show the transaction of the outbound or inbound phone call on the call detail records.
Does T-Mobile keep the cell site information for the call that the outgoing non-T-Mobile subscriber?
No.
What's the purpose of collecting this information at T-Mobile?
Billing purposes.
Is there any consideration as to the health and optimization of the network?
So we keep what is known as timing advance records, which is solely for engineering purposes, so that they are able to check up on the network, yes.
When a phone call is made from a cellular device or handset, can you describe from the network perspective, what happens?
Sure. So what happens is the phone reaches out to the tower with the strongest signal, which is not necessarily the closest tower. So for example, we can have a tower on top of the building, or we can have one down the street. However, the one down the street might be the stronger signal and would pick up that call. At that point, it's transferred to our switch, and our switch is what records all the information that you will see on the call detail records. At that point, it's then transferred to a landline company, and it's the landline company that actually delivers the call.
So you mentioned true call data. What is that?
So true call data is for the network. It will show where the phone is connected to when it's not in use, as long as it's turned on.
Does Sprint also have a similar type of data?
Yes.
What is per call measurement data?
Correct.
Is that the same for true call with the Sprint analogy?
Correct. That's Sprint's term.
In terms of subscriber information, what types of subscriber information is kept?
So the subscriber information, we have two types. One would be a prepay, and then the other would be a monthly account.
So the prepay, what type of information could you have?
So prepay, a customer is not required to provide their information, but they could provide a name, address, and date of birth.
On the postpaid or the billed type, what type of information do you have?
So we would have the name, the address, date of birth, social security number, and we actually do a credit check on that individual.
In terms of the individual using the specific phones or handsets, can you testify to that?
No.
How many times have you testified in court before?
Over 1,000 times.
Were you, as the records custodian for T-Mobile, provided legal process, I'm going to go through them one by one, under reference tracking number for T-Mobile, 214-6318, for two phone numbers of 305-922-9533 and 954-376-9158?
Yes.
As the T-Mobile records custodian under tracking number 219-2645, were you provided records and requests and legal process for three phone numbers, 561-720-3210, 772-713-9807, and 954-376-9158?
Yes.
As the records custodian for T-Mobile under T-Mobile tracking ID 208-1851, where you submitted requests for phone number 954-248-9081.
Yes.
For T-Mobile tracking number 217-2715, for phone number 954-376-9158, where you provided a legal process to obtain the records for that issue?
Yes.
Were you also under tracking number 205-8127, asked to provide for legal process phone number records for 772-713-9807?
Yes.
Was Sprint at the time, now part of T-Mobile, under the phone numbers for 772-713-2341 and 954-371-7895 under Sprint tracking number 2018-221418, provided legal process and requested to provide records?
Yes.
Was Sprint under Sprint case number 2019-15821 asked to provide records with regards to phone number 225-529-5054?
Yes.
Prior to coming into court today, did you have the opportunity to review the records that were provided?
Yes, I did.
Are these records made at or about the time they are created by a person with knowledge?
Yes.
Are they kept in the regular course of business of Sprint and T-Mobile?
Yes, they are.
Okay. Is it in the regular practice to keep such records?
Yes.
You're at this time approaching with what's been labeled as states 000 for identification purposes and previously shown to defense. Ms. Johnson, do you recognize this USB?
Yes, I do.
How do you recognize it?
My initials and today's date are on the USB.
And does those USB fairly and accurately represent the records that were provided by T-Mobile in response to the tracking numbers that we just discussed, as well as to Sprint and the tracking numbers and case numbers they just provided?
Yes.
Here at this time, the state would offer states 000 as state 63.
Any objection?
Yes, Judge. Objection? Relevance?
Sure, why don't you come sidewalk here? Thank you. So, objection overruled, it will be admitted. What's the next number?
63.
63 and evidence.
Permission to publish?
You may.
I'm sorry, I didn't catch you.
63.
So I'm going to start with the Sprint records. What are we looking at in this particular file, 2018-221418-6155597?
This would be the subscriber information.
And in terms of
looking at this particular one, I'm going to zoom in. What is the billing name for this?
Chris Thomas.
And going to the second one, what is the billing name on this one?
The first name is Dontavius. Last name is Withers. Withers.
At the top of this screen capture, there's a BAN number. Do you know what that means?
Yes.
What is that?
That would be the account number.
Does that correlate with the other data that's been provided?
Yes.
Going to now the same Word document file name. What are we looking at in this Sprint document?
This is also subscriber information.
So you had mentioned that billing account number, that BAN number?
Correct.
If you can touch the screen in front of you, you can write on it and it will show up on the screen for the jurors. So if you could point out where the billing account number is here. Okay. And then what is the phone number that was being used by this account, or the subject number?
772-713-2341.
And is this again for that Chris Thomas billing account?
Yes.
Okay. Scrolling down to the next billing account number. Is this the other account that we just looked at the subscriber information on for Dontavius Withers?
Yes.
And what is the phone number that's associated with this particular account?
954-371-7895.
Going on to 2019-158-210-6566861. For the phone number in question on this particular record, is that labeled right here?
Yes.
And what phone number is that?
225-529-5054.
And looking at the Microsoft Excel viewer, can you explain to the ladies and gentlemen of the jury what we're looking at here?
These are the call detail records with cell site information for Sprint.
Going over to the T-Mobile records. Just for demonstrative and illustrative purposes, when you are looking, this particular one called Timing Advance LTE and UMTS _TN 772-713-9807. Then it has another underscore IMSI. What is an IMSI?
That stands for International Mobile Subscriber Identity Number, which is the number that's associated with the SIM card found in the back of the phone.
And the first, the 772-713-9807. What is that?
That would be the phone number.
Are all of these records provided by T-Mobile?
Yes.
In terms of completion codes, is that something that is reflected in these records?
Yes.
What is a completed successfully completion code?
So that means that the call went through the network successfully.
What is an abnormal completion?
An abnormal completion means the call did not go through. Perhaps the user hung up prior to the call connecting, or a dropped call.
Okay. In terms of what time frame are all of these records kept in?
We keep them in UTC time, which is Coordinated Universal Time. So depending on what time of the year it is, you would have to subtract either 4 or 5 hours from the time that you see reflected in order to arrive at East Coast time.
On October 26th of 2018, how many hours did you have to subtract?
It would be -4.
The cell site locations indicate latitude and longitude of the cell site. Is that now there's also a physical address. Is the physical address always the same as the latitude and longitude?
No.
What could the physical address sometimes show?
So that's what we refer to as an administrative address. So we use that for 911 purposes. To get the exact location of the cell tower, you would take the two coordinates, the latitude and longitude, plot it into a mapping program such as Google Earth, and that will give you the exact location.
Is there nothing further of this witness, Your Honor?
Counsel, is there any cross-examination?
1 second, Your Honor. Good afternoon, ma'am.
Good afternoon.
How are you?
Good, thank you.
So, the technology that you just described for identifying locations, how is that verified by T-Mobile itself?
That you would have to ask an engineer for.
So you don't know how that's done?
How it's verified?
Yeah.
As to what tower connected to? Is that what you're asking?
Yes.
So it's done with a radio frequency, is how the towers work. It's a signal.
Okay, so but you were telling us earlier that the phone does not necessarily connect to the nearest tower.
Correct.
It connects to the tower with the strongest signal.
Correct.
So how is it that you know to approximate, how do you know how far the phone is from the actual tower?
I don't.
Is there no way to tell that?
No. Not through me.
Not through you?
Correct.
And how do you know if the tower that the phone connected to is the closest tower or the one with the stronger signal?
That would not be a question for me. You would have to ask an engineer.
How would you know whether or not a phone defaults to a stronger strength? If you have a tower with a strong signal and another tower with a not so strong signal, or a signal that's not as strong as the other. You with me so far?
Yes.
How would you know at what point the signal disparity is strong enough for it to default to the one that's further away as opposed to the one that's closer?
Again, that's a question for an engineer, not for me.
So you have no way of helping us understand any of this information that you just described?
Correct.
You just collect it when you're subpoenaed and you provide it.
Correct.
And you're not familiar with the technology at all?
Not the questions that you're asking, correct.
One second.
Sure.
Is it correct that the data location information, the purpose that you worked with Sprint and with T-Mobile at some point?
I'm a T-Mobile employee.
And you were a Sprint employee at some point?
No, sir.
You were somewhere else? No?
AT&T.
AT&T.
Correct.
the purpose that AT&T and in this case now T-Mobile collects this data location information is for billing.
Correct.
That's its only purpose.
And network engineers collect to optimize the network.
Okay. It's not used for identifying the locations of customers' phones beyond the purpose of just billing.
Correct.
Okay. Thank you.
Sure.
Thank you. Is there any redirect?
Yes, Your Honor. Ms. Johnson, counsel asked you, how do you know something didn't happen? Is that a fair question?
Objection.
Sustain. Rephrase.
With regards to these records, are they accurate?
Objection.
What's the objection?
Lack of foundation, Chief.
Why don't you come sidebar? The objection was sustained. Rephrase.
No. So, Ms. Johnson, with regards to the records, does the T-Mobile keep any record of something that doesn't happen?
No.
What is contained in the records that have been provided?
Calls and text messages.
We share these roads. So look out for each other. And remember, it's okay to be nice.
Good afternoon.
Good afternoon, sir.
Are you Jonathan Zella?
I am, sir.
Welcome. Come on up here, sir. That's our witness stand. When you get there, you put your things down, you raise your right hand, be sworn.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Jonathan Zella. This is Z-E-L-L-E.
Spell your first name as well, sir.
Jonathan.
Thank you.
Under that microphone, will just up or down, but not back up.
Yes, sir.
Counsel, if you're ready, you may proceed.
Good afternoon.
I'm sorry. Can we approach very
and put your name.
Thank you. Anything else, Councilman?
No, Judge.
Bradley, if you're ready, you may proceed.
Okay. Detective, how are you today?
I'm good, thank you.
Good. Where do you work?
I work with the Miramar Police Department
How long have you worked for the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009.
Prior to going into the homicide unit, what other hats have you worn for the Miramar Police Department?
Several. One in particular is the forensic, digital forensic examiner.
Okay. What is a digital forensic examiner?
So what I do is we'll stick with the cell phones or cellular phones or devices of that nature. I do the extraction and the analysis for it.
And when you're doing an extraction, can you explain to the ladies and gentlemen of the jury what types of software or tools you use to do an extraction on a cellular telephone?
Okay, so what we use is a software and hardware from a company called Celebrate. And this is specific for conducting extractions of cellular devices.
And approximately how many different trainings have you taken in the use of Celebrate systems?
I've taken a few. Each of them consist of 40 hours of class training and exercises, and obviously the exam as well.
What about, have you taken training with the CAST team of the FBI?
I have.
Have you taken, you said you also do analysis of the cellular forensics or digital forensics. What do you mean by that?
So, depending on what type of case it is, I will actually do the extraction and I'll also do the examination of it, the analysis for it, and go through it and look for items that potentially could be considered evidence.
And in terms of to do the analysis part, what information do you need?
I need to know about the case.
In this case that we're here on today, Miramar Police Department Investigation 18-10-06269, were you the lead detective?
I was not.
What was your role in this case?
Doing the analysis or the extraction of the device.
Did you do any analysis of the device?
I did not.
In terms of the extraction of the device, were you provided an iPhone with the phone number attached to it of 772-713-9807?
Yes, yes.
Prior to coming to court today, did you have the opportunity to review the digital copy of that extraction?
I did.
I'm showing defense counsel. Leslie Marcus states triple P for identification purposes, showing the witness. Detective Zeller, do you recognize this thumb drive?
I do.
How do you recognize this?
My initials and my ID number on the jump drive.
What is that thumb drive contain?
This is the generated report of the generated report of the cellular device that was extracted.
And is that in the same or substantially the same condition as when you performed that extraction?
Yes.
Here at this time, the state would request to move states triple P in as state 64.
Objection. Yes, sir. Name.
Sure.
Ladies and gentlemen, we got him.
The 2023 Kia Sportage was built for more. More room for your passengers, more cargo space for your things. Simply put, more room for adventure. Where the road takes you, the Kia Sportage is ready to accommodate. Stop in and see us at the summer sales event. Grab a fantastic offer and get behind the wheel of your new Kia.
Objection to overrule the admitted.
4.
What's the next number?
64.
Thank you.
So Detective Zeller, can you explain to the ladies and gentlemen of the jury what an extraction does?
So the extractions consist or is done in order to obtain whatever is on that phone and to put it in a legible or readable report that's easy for someone to look at. And some of the things that you would get also by doing that, you may get items that have been deleted and so on and so forth. And that's why we do those types of extractions.
Nothing further from this witness, Your Honor?
Any cross-examination?
Yes, just briefly. How are you, sir?
Good news, sir.
You said you did a phone dump here of a particular unit that the state referred to.
That's correct.
And you have not analyzed it?
No.
You don't know if there's any relevant evidence on it at all?
That's correct.
Okay. And you don't know who it belongs to, do you?
I do know who it belongs to. Obviously, I'm in the office. I know who it belongs to, but as far as the contents of it, I don't know.
You don't know. You don't know who uses it.
I do not.
You don't know who it's registered to.
I do not.
Okay. One second. And as to any contents of that phone, you don't know if they're texts, who authored them.
Once again, I don't know the contents of it.
Your Honor, we'd like to come sidebar if you would. Sure.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, Mr. Daniels. Defendant, you need a restroom break? Need a restroom break? Nope. All right. Thank you. And what is it you all want to share with the cases?
Okay, Your Honor, and I can hand them up as I discussed them. I don't think I left one with the court. The one that I referred to first is RLG versus State, 322 Southern 3rd, 721, a third DCA case. This is an app on a phone that purports to account for the number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church, and every time she goes to church and comes back, she's taken 20,000 steps because she's doing like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology. Because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication hurdle to, as a foundation, establish that that technology is a reliable one. Because she is going to now, and she's introducing the matter for the truth, told the jury in opening, Mr. Demons, who she believes had the phone but has no proof of that to begin with, walks 70 steps. Says who? Says an app. What app? The one in his phone. Is it reliable? We don't know. Why? Because she has not established the reliability of the technology as a predicate to the admission of the data. So that is our number one foundation argument.
A case that you want me to read?
Yes, sir.
I'm happy to take a look at it.
Thank you.
Yes, madam.
Here, I first start with citing back to State versus Maximit, which is a 1967 case, which was the earliest time in which I could find a pedometer being mentioned. And at that point, it's important to note this is a well-established technology that's been in use for hundreds of years, initially done by train conductors to measure out distances. It's also allowed under the Florida statutes and used to be used to measure out distances for determination of 1,000 feet from a place of worship, a school, or anything else, for measuring distances for enhancement on drug penalties. So I'd start by handing that one to Your Honor. Then I also have State v. Birch, which is a Wisconsin case in which similar information was admissible and used in a homicide case. Then also in the issue of cell phone dumps, and that's at 398 Wisconsin 2nd 1. And then even more recently, this was a federal case, United States versus Rigo, R-I-E-G-O. I just have a Westlaw site because it's 2022, it is not yet. This is 2022 Westlaw 175-46714. And again, those discuss all of the location information and the activity and Apple Health data that was admitted in those cases. And I'll be happy to email copies of those to defense counsel now.
Thank you. All right, we're in recess. I'll read them over.
Your Honor, may I also just direct your attention to a few articles, one of which indicates the highlight here. The reliability of the registered distances, however, depends on a number of factors, including walking speed and walking style of the subject, and can deviate up to 30 to 40% from the true value. That's one of the several articles here. And what I will do is I will compile the articles and send them all back for your review while you're considering the issue, if you don't mind.
Sure. And the state would also submit in terms of law review articles, including a 2016 wearable devices as admissible evidence. Technology is killing our opportunity to lie. The 2019, the iPhone health app from a forensic perspective can stats and distances registered during walking and running being used as digital evidence. And I would direct your Honor's attention to the Supreme Court of Alabama. That was Jeffrey West. The individual in that case was convicted as well based on some of the Fitbit data.
And may I just ask if the state is making the representation that all the cases she's citing to do not require that a witness establish the reliability of the technology? It's just put in?
It has been admitted, and I have some of the, send everything that I'm giving to His Honor is copy to you as well.
Okay.
Thank you. We're in recess.
Thank you, Judge.
when a juror is pulled out of the jury room, sat down, and being asked questions. Now, let's remember how this happened. This was because she asked a question of the prosecutor, and there is an admonition that you shouldn't speak to the parties. And the prosecutor, if I heard this right at the time, indicated that he didn't know anything about it, about the mistrial motion. Now the judge comes out, it's clean. She heard about the mistrial motion because it was stated in court. And that's what she was asking about. She didn't hear from an outside influence. But I got to tell you, if I were the prosecutor in this case, I'd be concerned that a juror got pulled out. The juror clearly knows I'm the one who gave the information to the court. And I told the juror that I didn't know anything about that, which they shouldn't have said in the first place. The juror may not all be too happy with the prosecutor at this point. Thoughts?
I agree. They might think, well, hey, you know, everything I'm saying, even this little unimportant thing is going to get back to the judge. But on the other hand, it may also strengthen the credibility of the prosecutor, right? Because the juror's not going to say, hey, you know what, this prosecutor plays by the rules, is above board, and doesn't want there to be any bias, any prejudice, anything like that. So it cuts both ways, to be honest.
Yeah, I don't know. I guess let me go to the FBI, CIA, specialist over here. I just think that could be tried. It's a fair point. But he also said he didn't know anything about that when she clearly knows it was said inside the courtroom. So I'm not sure if that really is going to bolster his credibility in her mind. And nevertheless, she got kind of called out. It's just sloppy. It's just something that the prosecutor shouldn't even, I'd be thinking about it, and I don't want to be thinking about stuff. What do you think?
Well, I see where Miguel is coming from for sure, because I do think that it does ultimately cut both ways. But Bob, I really appreciate you saying what you did about how it really is about winning the hearts and minds of the jury. I've said that on here before, and sometimes to the chagrin of other people, but that's the bottom line. And that's what ultimately matters in this. And I do think that a juror who's being called out by the judge, and he's not doing it in an inappropriate way, but that is an incredibly intimidating situation in an already precarious situation, quite frankly, that they're in. This is somewhat of a charged courtroom. And so I really don't think that ultimately this is going to bode well for the prosecution in this case. However, I don't know that it's going to sort of be the ultimate nail in their proverbial coffin, if you will.
Yeah, listen, there's a whole Olympic-sized swimming pool of data that goes into winning a case. I guess I was the kind of person that didn't even want to see a drop come out of that pool. So you're right. It probably has no great effect, but in the end analysis, just another unforced error. On a note, we're going to take a break. We'll be back on the other end. Please stay with us.
Allergies. Get ready to take on all three. Introducing Astapro Allergy. Nasal allergy symptom relief that starts working in 30 minutes, so you can get back to feeling sexy, fast. Because no one feels sexy with allergies.
Welcome back to Law and Crime. Nobody's doing as good as us in covering these trials because we have two great guests. And guys, we only got a couple of minutes left, so I'm going to turn the show over to you. We'll start with Tracy. Thoughts about the whole case, where we are, where we've been, and where do you think we're going?
I really think motive. Motive. That's what I keep saying about this case. That's something that really hasn't been discussed. It's something that, quite frankly, is missing. They have a lot of digital data, a lot of forensic data, and quite frankly, a lot of biological evidence as well. However, the motive seems to be missing. And I think the prosecution really needs to be focusing on that. I know you don't necessarily need that to convict, but again, I think it will bode a long way with jurors if they want to be successful in obtaining a conviction here.
Yeah, and Miguel, not that what Tracy said is nails on a chalkboard to me, because it's not. She's right 1,000%. Motive is not an element of an offense. That does not have to be proved. But like she's saying, its motive is still so important in a case like this. So, and so I don't agree with you. I shouldn't say it's nails on a chalkboard. It's nails when people say it doesn't need to be proven, and then they end. They don't talk about how important it is she did. What are your thoughts?
I totally agree with Tracy. You don't have to prove the motive or show a motive, but here's the thing: the jurors, they're they're people just like everybody else, and they want to know why, right? Why, if these two deceased were in the same group, in the same musical group as the defendant, why would he shoot them, right? Was it for gangs? Was it for money, profits? What was going on? Business disputes? So I think it's super important that they get to that why, because everybody wants to know why. Why did it happen?
Well, Tracy, let me go back to you. Why did it happen? And what really shocks me about this, let's keep in mind, this is a death penalty case. And even if they get a capital murder conviction, it goes into the sentencing phase, the penalty phase. And one of the aggravating factors is that this was a gang-related shooting. I don't know, where's the beef? I don't know where the evidence is, whatever. Maybe it's that, maybe it's something else. If we don't have motive in a case like this, how do they get to that significant aggravating factor to justify the death penalty? And if they can't, why is this a death penalty case?
I think you hit the nail on the head, and I know it's like nails on a chalkboard. And again, you don't have to have this to convict someone. I get it. But again, you've got these aggravating factors that they've brought into play here. And if they can't prove that why, particularly in the gang offense, then they've essentially overcharged him, over-sentenced him, if you will. And that will be problematic and can result in a not guilty verdict.
Yeah, well, let me ask you, Miguel, and we're going to give you the last couple of seconds here. This now no longer has to be proven by 12 people. The law has changed, and now only 8 people have to vote with the death penalty. Is it possible we're going to start getting more death penalty verdicts that we previously would not have gotten on weaker evidence because we've lowered the standard? And if so, what do you think our appellate courts will do with that, including the U.S. Supreme Court? I've got about 45 seconds.
I think it's going to keep the appellate courts very busy. The fact that it's lowered down to 8 means that you're right, there's going to be people that are going to be convicted on weaker evidence, and that's problematic, right? Because, I mean, we're talking about the ultimate punishment, right? And so I definitely think that it's probably going to be something that's going to go to the Supreme Court. I really think that this is going to be an issue that's going to be revisited. 8-4 seems, it's troublesome.
Yeah, well, this is exactly the reason. If you keep lowering the standard down, I guess eventually, even though the quality of the evidence may be weak, you're eventually going to get somebody to say vote for the death penalty. Maybe we should go down to 2 or 1. I don't know. Guys, thanks very much. That's it for us. Don't go anywhere. In capable hands, Imran Ansari is next. Have a great rest of the week.
Good afternoon and welcome to the Law and Crime Network. I'm Imran Ansari. Our trial coverage takes us to Broward County, Florida, for the trial of rapper Jamel Demens, better known as his stage name, YNW MELLY. The South Florida rapper is charged with 2 counts of first-degree murder for the deaths of his friend Christopher Thomas Jr. and Anthony Williams. Thomas, who was known as YNW Juvie, and Williams, who was known as YNW Sack Chaser, were all part of the YNW collective, along with co-defendant Cortland Henry, who will be tried separately. Court was off to a late start today, only calling their first witness of the day this afternoon, before court went on a brief recess, but there were some discussions outside the presence of the jury. Let's head into that courtroom for more now.
An app on a phone that purports to account for the number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church. And every time she goes to church and comes back, she's taken 20,000 steps because she's doing like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology. Because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication, or at least the expert, not even the method, and so we raised the Daubert issue. We gave notice of an expert. The state took issue with it, raised the Daubert objection to it at that time. This is not a situation where the state presents us an expert. And we can't anticipate that the state is going to try to admit evidence before they admit it without the necessary predicate. And those cases actually speak to the objection being made at the time that it is sought to be introduced. As a matter of fact, some of those cases rejected the appeal because even though the predicate wasn't made, the objection wasn't made at the time the evidence was sought to be introduced. The state sought to introduce evidence without laying a foundation. Our objection is objection foundation. We're not making a Daubert objection to an expert who's testifying. He doesn't purport to be an expert. This is not a Daubert situation, Judge. This is a lack of foundation situation. And the fact that that foundation needs to be presented by somebody with expertise and knowledge doesn't make it a Daubert question. It's a foundation question. And before the state, I think those cases are clear. If the state is planning to put evidence in that relies upon the technology, they first have to establish the reliability of that technology. And that's the basis of our objection with respect to this step data. We've also made a relevancy objection to the fact that there is a wholesale dump of information coming in through a witness who said, I haven't even looked at it. How do we know that the information in there is relevant? How do we know that the information that has been introduced is not more prejudicial than probative, even if relevant, on a 404B? How do we know that it's not doesn't contain 404B evidence that's inadmissible? The state has to establish the relevance of the information they seek to put in. They can't just put in everything from a phone and pick through what they think, and then the jury has in its possession a host of majority information that's not relevant to the proceeding, which is prejudicial. So that is the other basis for our objection. Also, a lot of the information contained there is hearsay. They said, well, it's his phone, so there's no hearsay objection. There are texts between people. There's also evidence that we have that establishes that that phone was being used. The phone comes up as the name Sack Chaser Howard. Sack Chaser is the nickname of one of the decedents. That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedents' name as the identifier. It's in the name of Jamie King, not Jamel Demons. It was retrieved from Jameson Francois, not Jamel Demons. So it's neither in his name, it wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. We have information here that indicates that, definitively. It shows the phone being used to call. It shows the same step data from that very unit after he is incarcerated. So it's obvious that it's being used by several other people. So we can't even say that it's his phone and the information there is therefore all relevance, all information on it is non-hearsay because it's statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's in somebody else's name, retrieved from someone else, and this witness has not analyzed a single letter of all the information they're seeking to put in. So there is a ton of irrelevant evidence that is being introduced, and a lot of it is going to be prejudicial, 404B and 403 evidence, and that's why we objected before. I didn't wait until after, because one of the points that the court made is you already let it in. We objected before, Judge, and you told us, overruled, let it in. It's still a problem right now, and we're trying to stem the damage before it goes too far. And we think that the issue has to be addressed before this information is used and it goes forward, both on the foundation issue, on the technology issue, authentication issue, relevancy issue, 403, 404B issue.
Thank you. The relevancy issue is relatively low, counsel. My understanding, where's the phone located at, counsel?
The phone itself?
Yeah.
That will be introduced through the
No, where was the phone located?
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that, goes back to this defendant.
Then they have to establish it before they put it in, not after the fact, on this notion that they possess information that makes it relevant. If they do, present it, and then it's relevant at that time. We have, Your Honor, indications of this cell phone and this Instagram account that the state has introduced. The Instagram account is being used to post pictures days after his arrest, up to and including pictures of this very trial last week. This Instagram account is being used and accessible to a number of people. This notion that, oh, it's his account, he's an artist. It's a public account that several people have access to.
I'm sure you're going to be able to ask those type of questions, counsel. My thought is this, counsel. It's not fair to basically give me an inch worth of things to read, cases to read, articles to read, saying it's how it's not, the methodology is, and basically a Daubert issue on it. It's not clear. It's not been established. All those types of things that should have been done pre-trial. I haven't seen what's on the account. I don't disagree with that. Counsel's telling me it's relevant because of X, Y, and Z there. You're saying it's not, but I don't know what is the 403 analysis, what's more prejudicial than probative. I haven't seen anything about that. I don't know what it is. I haven't seen it. You haven't made me aware of it. You're just saying something's more prejudicial than probative. If it is, I'm more than happy to go through one at a time with you and find out. But as far as who used the phone, what was it being done, counsel's saying it's relevant to establish his phone. So I've made my ruling. You've made your objection. So everybody knows where they stand on it. All right, so it's admitted.
Okay.
All right.
Thank you.
All right, bring the jury back in.
process, Mr. Ballard, are you finished with your cross? Or do you have additional questions? Yes.
I don't think he has any relevant information. He said.
So you're finished?
Bring the jury.
I may ask a few.
Jury entering.
Ladies and gentlemen, thank you. Sorry for the delay. Please be seated. Let the record once again reflect the presence of the defendant, his counsel, the assistant state attorneys. Ladies and gentlemen of the jury, our witness remains on the stand. So you have questions, counsel?
Yes, I have a few more, Your Honor. Thank you. You did, sir, 2 data dumps from the device in question?
Are they 2 or 1?
You did 2 of them, did you not?
I did on this device, I did 1 extraction.
You only did it once?
If I recall.
Did you have the data verified by any third party for completeness of the download?
No.
And you made that decision, was it your decision whether or not to do that kind of verification?
Yes.
Okay, and you elected not to?
Correct, I would not to.
Did you have an engineer review any of the data that you retrieved?
No.
And have you validated that the Cellbrite extracts in the data that you did were in fact complete?
The extraction is the extraction, and that's what I got out of it. That's what the machine gave me, yes.
Okay, and how did you verify that the machine gave you a complete download?
I don't understand when you say a complete download.
You said you don't understand what I mean?
No, you can elaborate on that.
How did you verify that the machine, the Cellbrite software that you used, downloaded the contents of the phone in its entirety? How did you go about verifying that?
That is not something that I can verify. That is whatever the data that comes from that phone and appears on the software. That's what I have. That's what I can deal with.
Okay, so you can't verify?
I cannot, no.
Is there a process of maybe testing, is there another, first of all, software that you can use to download the information?
Sure, there's other software.
And you only use the Cellbrite?
Correct.
And if you used another software and compare the downloads, that would be one way for you to test it, whether or not the download was complete, right?
In theory, I guess so, yes.
In actuality.
All right, I'll stipulate that.
Okay. So when you say there's no way to do it, it is what it is, what you're saying is there is a way to do it, and you didn't do it.
If that's what you want to call it, but it's not true. That's not correct.
Oh, so you did test it on another software?
No, I did not, but this is the only software that I have available to me.
Okay, so it's not that you had another software available to you that could help to verify the completeness and accuracy of your results. It's that you can do it, but you didn't have that software available to you.
Well, correct, I did not do it, no.
Do you know anything about the testing of the technology of Celebrite as to its efficiency and operability?
No, I don't. I'm not an engineer for them.
So you, pardon me?
I'm not an engineer for them.
Okay, so it would take an engineer to do that?
Or somebody from that company, not me.
Okay, so it's like any kind of software. If you have the software and it doesn't work in totality or it doesn't work completely, you're stuck with the answers.
I'm not understanding what you're trying to get at, but if you rephrase it one more time, I appreciate that.
If that Celebrite did not give you a complete and accurate download, you would have no way of knowing it.
That is correct.
Okay, because you didn't have comparable software or similar software to test the results against.
Correct.
Okay, so you're just trusting in the faith, you're just having faith that the Celebrite.
Sustained.
You are relying upon the accuracy and completeness of the Celebrite technology, right?
That's correct.
Even though you don't know anything about whether or not it works properly.
Correct.
Okay. Have you ever done a data dump from a phone more than once? Any phone?
Yes.
On Celebrite?
Yes.
And was it a phone that left your possession and then you regained possession of it?
When you're saying left my possession, I'm sorry.
In other words, it left the custody strikeout. In the instances when you have downloaded information from a phone on using Celebrite more than once, I presume you did it for a reason.
So one of the reasons why I probably would do it is maybe a software update from Celebrite.
Okay, that's one of the reasons. What else? What are the other reasons you might do it?
That's the only reason that I would use it.
Okay. Can I have one more, Your Honor?
Yes.
So it is your testimony, sir, that you didn't do an extraction from this phone in June? What year is this? And then another at a later date?
I don't recall.
At an earlier date in April?
I don't recall.
Well, you have any information there before you? Any of your reports that would indicate that?
I have one that was completed on February 28th.
February
2019, I think it is.
Okay. Nothing further. Thank you.
Counsel, is there a redirect?
Briefly, Your Honor. Detective Zeller, counsel asked you whether or not Celebrite is accurate.
Correct.
In your training and experience, can you speak on that particular subject?
Objection?
What's the objection?
This witness has already testified that he can't speak.
Sustained.
So Detective Zeller, in terms of you've used Celebrite numerous times.
That's correct.
Approximately how many?
Hundreds.
Have you found any instances in which Celebrite added data to a forensic download or that wasn't on the phone itself?
I'm sorry.
Objection.
Suggestion.
You would have no way of knowing that.
Overruled.
Can you answer one more time?
Have you ever had an instance in which Celebrate has added data to the forensic extraction or data dump that was not on the phone itself?
That was not on the phone? Not that I'm aware of.
In terms of the way to physically review, how would you do that on a cell phone and compare it against a Celebrate extraction?
Well, there's a couple things I could do. I could look at the different artifacts that are extracted, meaning, so I would look maybe at a particular phone call was made at a certain time and date, or a certain picture that was there at a certain time and date, or a video, or so on and so forth, whatever that's there. That's one way of doing it, yes.
So I want to make sure I'm clear. Are you saying you would look at outside evidence from the phone and see if it agrees?
Correct, yes.
In terms of the information and the data that's put out there, what is the purpose of taking it off the phone?
Well, you also don't want to use the original and just pretty much making a copy of the phone so that you don't ruin anything, delete anything, or compromise the device, or anything of that nature. So you work off that copy.
In terms of when the phone is brought to you, are there steps that are taken to make sure that there's no outside or internet or network access with the phone?
Yeah, so usually the phones are put in what's called airplane mode, where you disable all cellular connections.
And in terms of the type of extraction that was done in this case, what type of extraction was done?
This is called an advanced logical extraction. So,
what does that mean?
So there's different forms of extraction. The advanced logical pretty much gets, for the most part, when I use the word everything on there, when I say everything, meaning the context, their pictures, their videos, the communications, any sort of communications that are on there, deleted items, specifically deleted items.
Okay. And in terms of to get the advanced logical extraction, what information do you need as an examiner?
Meaning, I'm
Do
sorry.
you need the passcode to the phone?
Yes, you do need the password, correct, yes.
Oh, nothing further, Your Honor.
Is this witness excused?
Yes, sir.
Thank you. You may step down. You're excused.
Thank you, sir.
Thank you. For your next witness, please.
Brendan Collins.
Thank you. You, Brendan Collins.
Yes, sir.
Welcome. This is our witness stand. Can you go over here, please? When you get there, just remain standing for a bit. Raise your right hand and be sworn.
You solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Please state your full legal name for the record.
Brendan Collins.
Please spell your first and last name for the court report.
My first name is spelled B-R-E-N-D-A-N. My last name is spelled C-O-L-L-I-N-S.
Thank you, sir.
Thank you. Please be seated. Mr. Collins, that microphone in front of you adjusts up or down, but doesn't move back and forth.
Thanks, sir.
You ready?
Yes, sir.
Counsel, you may.
Thank you. Good afternoon, Mr. Collins. How are you?
Good afternoon, I'm doing well.
Where are you employed?
I'm an FBI agent, so I'm employed by the Federal Bureau of Investigation, and my full job title is Supervisory Special Agent.
And how long have you held that position?
This current position, about 18 months. I've been employed by the FBI for since 2012.
And as far as education, what types of degrees do you hold?
I have a bachelor's.
And is it in a specific area?
I was a history major in college.
Were you employed anywhere else prior to working for the FBI?
By the Army.
And how long were you employed by the Army?
About 6.5 years. I had a couple different jobs.
Okay. Going back to where you're working now, the Federal Bureau of Investigation, what are your responsibilities as an FBI agent?
Well, agents do all sorts of different things. Generally, agents are all investigators, and in the FBI, we investigate a myriad of crimes, from violent crimes, economic crimes. We also have national security mandates. Me specifically, right now, I'm the supervisor of a squad that focuses on transnational organized crime.
So do you also have an ancillary assignment?
Not right now. I used to.
Would you explain to the ladies and gentlemen of the jury what is the CAST team for the FBI?
Sure. So CAST, for the Cellular Analysis Survey Team, is a group of specially trained and equipped agents and task force officers who do cellular analysis or mobile device location analysis.
And so when you say that, what types of records are you working with?
Usually records from phone companies or other service providers.
Okay. Can you explain to the ladies and gentlemen of the jury what is historical cell site analysis?
Sure. So when someone uses a phone or a mobile device to do something, to make a call, to send or receive a text, to check a sports score, or check their email, post something on social media, that's to connect to the cellular network or through the internet. When you connect through the cellular network, there's a record that's generated by your phones, by the phone company. So you have T-Mobile gives you service to your cell phone. When you make a call, you'll see records on your T-Mobile sheets about that call. Historic cell site analysis is using those records to answer questions.
So what's the purpose of historical cell site analysis?
To help with investigations.
And what are the main components of a historical cell site analysis?
Well, if you're being asked to do like a location analysis, in other words, the case involves trying to determine where a particular device was at a certain point in time, you really have three things that you need. First, you need the records for that particular device. That will say that it'll look at the initial records, like a call detail record, for instance, will sort of look like a billing statement that you might get from a phone company. It will say, this date and time, this phone number, place this call to this other number, etc. Except it will also have additional information. It will say a cell tower that the phone connected to when it made that call. So you need that record about the device. You also need a record of tower locations that says, okay, the tower the phone connected to is located at this particular point on the earth. You put those two things together into some sort of mapping software and it plots it, and then it will give you a general area of where the device was at the time that it connected to that tower.
So you said device. Can you testify a specific person was in a specific area?
No.
Why not?
Because the records I have are just about devices.
Okay. So there are limitations to your testimony.
Yeah, absolutely. Yeah, I'm talking about devices, not people.
Have you received any specialized training to become an agent that does CAST as
Yes.
well? What is that?
To be CAST certified is pretty extensive. There's several stages that the certification process is broken into. So I started my initial training in 2017. The first phase of training is the CAST basic course. That's a 2 or 3 day course where agents and officers from our local, state, or other federal agencies are exposed to what cellular analysis is and how to do it at the basic level.
Do you use the CAST work in your day-to-day cases? Before you became a supervisor?
Yes.
And so is this a required assignment to go to the CAST team?
No, I don't want to interrupt, but there's a lot more training than just that 2 day thing. Is that okay?
Let's start with, to do that first 2 day training.
Yeah, so the first
Is that mandatory for
Yes.
the FBI?
Yeah.
To go on past that, is that something you have to apply for?
Yes. Yeah.
Okay, and to explain after that first initial training, what happens? What's the next level of training you complete?
So the next course is called the advanced course, and it's a week-long course. And that's just a more in-depth dive into each of the networks. So specifically, what are the uniquenesses of, say, Verizon or T-Mobile, AT&T, Sprint when it was a standalone provider, what do their records look like, what are the uniquenesses of the way their network's designed, et cetera. After the advanced course, then we have a sort of a test. It's like a week long. When I went through, it was a mix of part in the classroom and part in the field, where it's all scenario based. So, for instance, you'd be like a kidnapping scenario. You'd be like, hey, this child was abducted. Your job as the asset going through it to try and use the records to develop a search location and say, hey, I think that we need to go here to try and recover the child. You do a portion in the classroom, you do a portion in the real world where they have test runs set up in different locations, and you validate the results right there. So you either find the person or you wouldn't, and at the end you either pass or fail. So I passed, and I was allowed to continue to the certification course, which is a 4-week course. The first 2 weeks are very academic. We have a week that's basically a semester's worth of material condensed into a week. It's put on by professors from the Florida Institute of Technology. We bring in representatives from all the major cell phone providers in the U.S., both their law enforcement relations and records custodians personnel. We talk about these are the types of records that we keep in our specific record, or our specific company. We also bring in personnel from the network engineers, so the people who build the network, who design it. We go to infrastructure, so I've been at the Sprint Network Operations Center where they oversee the management of the whole the network across the country, et cetera. And then at the end of that, there's a test, and you either pass and are certified, or you don't.
Okay, so Special Agent Collins, are you certified in CAST analysis?
Yes.
How long have you held that certification for?
I got certified in September of 2018.
Is there continuing education or recertification that's required?
Yes. So to keep your CAST certification, every year you have to attend a recertification course.
Okay. Is all of the training specifically from the FBF?
No.
What other agencies and I guess companies do the training for you?
Yes, we have partnerships, or not partnerships, but we'll bring in educators from a lot of different companies. So obviously the different telecommunications companies are critical. So we have them come to the recertification conference every year. We've had a range of other people. We've had Apple, Qualcomm, Oracle, people in the field of GPS, cellular engineering, vehicles for vehicle telematics, and anybody that's sort of involved in that ecosystem.
Okay, so you mentioned Apple, Qualcomm. What are those?
Those are different manufacturers.
Is there also specific as to cellular technology and how it works, training on that?
For what?
In terms of being a CAST certification.
After recertification?
Yes.
Yes.
Okay. How long have you been specializing in call detail records analysis?
So call detail record analysis is really like the bread and butter of what CAST does. So since I started the training process in 2017, that's when I first really got exposed to working call detail records or CDRs.
Okay, and approximately how many times have you done this type of analysis?
I've done more than 130 cases and that have included more than approximately 300 sets of records.
When you say a set of records,
yeah,
what does that mean?
Like a call detail record or an engineering report, some sort of data report, some sort of report from a phone company about a particular device.
And in terms of the types of cases that you've worked, what have they been?
A gamut. Violent crimes like homicides or shootings, white-collar crimes, have been public corruption, crimes against children, terrorism.
Okay. Have you worked cases where you've been called upon to determine the location of a cell phone?
Yes.
How many?
And for the 130 so cases that I've helped with, the vast majority of those have to do with location, historical location of the phone.
Have you had the opportunity to validate your historical call data reconstructions, or that you do?
Yes.
And how do you do that?
Well, as we mentioned sort of during the, I was talking about the train up, if it's a situation, a case where we're trying to find someone who we believe is in possession of the device, do an analysis and you say, I think we need to go to this house, and we go there and the person and the phone are there, that's validation. If we have a case where we have some sort of other evidence that corroborates it, like in a crimes against children case, and there's metadata on media that was produced at a specific location, and we have cell site that says, okay, we know this film or something was produced here, and here's what the cell site looks like, and that corroborates it. A couple examples.
So when you say metadata, can you explain what that is?
Yeah, that's outside of what I do with CAST, but that would be something that would be in a media file, perhaps, that somebody else, who if you extract the file from a phone using a physical extraction device or a computer or some other device, sometimes there's metadata embedded within the image or the video or whatever that will tell you different things, such as when the picture or movie was produced, where it may have been produced, or the picture may have been taken, etc.
Here, just going to offer Special Agent Collins as an expert in the area of historical cell site and cellular technology, and offer for water.
Hey, you want to come side for a second? Thank you. Thank you. Can we arrange for a restroom break for Mr. Demons, please?
Yes, Judge.
We'll be in recess.
Mandates. Me specifically right now, I'm the supervisor of a squad that focuses on transnational organized crime.
So do you also have an ancillary assignment?
Not right now, I used to.
Would you explain to the ladies and gentlemen of the jury what is the CAST team for the FBI?
Sure. So CAST, for the Cellular Analysis Survey Team, is a group of specially trained and equipped agents and task force officers who do cellular analysis or mobile device location analysis.
And so when you say that, what types of records are you working with?
Usually records from phone companies or other service providers.
Okay. Can you explain to the ladies and gentlemen of the jury what is historical cell site analysis?
Sure. So when someone uses a phone or a mobile device to do something, to make a call, to send or receive a text, to check a sports score, or check their email, post something on social media, has to connect to the cellular network or through the internet. When you connect through the cellular network, there's a record that's generated by your phones, by the phone company. So you have T-Mobile gives you service to your cell phone. When you make a call, you'll see records on your T-Mobile sheets about that call. Historic cell site analysis is using those records to answer questions.
So what's the purpose of historical cell site analysis?
To help with investigations.
And what are the main components of a historical cell site analysis?
Well, if you're being asked to do like a location analysis, in other words, the case involves trying to determine where a particular device was at a certain point in time, you really have three things that you need. First, you need the records for that particular device. That will say that it'll look at the initial records, like a call detail record, for instance, will sort of look like a billing statement that you might get from a phone company. It will say, this date and time, this phone number, place this call to this other number, etc. Except it will also have additional information. It will say a cell tower that the phone connected to when it made that call. So you need that record about the device. You also need a record of tower locations that says, okay, the tower the phone connected to is located at this particular point on the Earth. You put those two things together into some sort of mapping software and it plots it, and then it will give you a general area of where the device was at the time that it connected to that tower.
So you said device. Can you testify a specific person was in a specific area?
No.
Why not?
Because the records I have are just about devices.
Okay. So there are limitations to your testimony.
Yeah, absolutely. Yeah, I'm talking about devices, not people.
Have you received any specialized training to become an agent that does CAST as well? What is that?
To be CAST certified is pretty extensive. There's several stages that the certification process is broken into. So I started my initial training in 2017. The first phase of training is the CAST basic course. That's a 2 or 3 day course where agents and officers from our local, state, or other federal agencies are exposed to what cellular analysis is and how to do it at the basic level.
Do you use the CAST work in your day-to-day cases? Before you became a supervisor?
Yes.
And so is this a required assignment to go to the CAST team?
No, on the but there's a lot more training than just that 2-day thing. Is that okay?
Well, let's start with to do that first 2-day training.
Yeah. So the first.
Is that mandatory?
Yes.
Yeah.
Yeah.
To go on past that, is that something you have to apply for?
Yes. Yeah.
Okay. And to explain after that first initial training, what happens? What's the next level of training you complete?
So the next course is called the advanced course, and it's a week-long course, and that's just a more in-depth dive into each of the networks. So specifically, what are the uniquenesses of, say, Verizon or T-Mobile, AT&T, Sprint when it was a standalone provider? What do their records look like? What are the uniquenesses of the way their network's designed, etc. After the advanced course, then we have a sort of a test. It's like a week long. When I went through, it was a mix of part in the classroom and part in the field, where it's all scenario based. So you, for instance, you'd be like a kidnapping scenario. Like, hey, this child was abducted. Your job is the asset going through to try and use the records to develop a search location and say, yeah, I think that we need to go here to try and recover the child. You do a portion in the classroom, you do a portion in the real world where they have test runs set up at different locations, and you validate the results right there. So you either find the person or you wouldn't, and at the end you either pass or fail. So I passed, and I was allowed to continue to the certification course, which is a 4-week course. The first 2 weeks are very academic. We have a week that's basically a semester's worth of material condensed into a week. It's put on by professors from the Florida Institute of Technology. We bring in representatives from all the major cell phone providers in the U.S., both their law enforcement relations and records custodians personnel. We talk about these are the types of records that we keep in our specific record, our specific company. We also bring in personnel from the network engineers, so the people who build the network, who design it, We go to infrastructure, so I've been at the Sprint's Network Operations Center where they oversee the management of the whole the network across the country, et cetera. And then at the end of that, there's a test, and you either pass and are certified, or you don't.
Okay, so Special Agent Collins, are you certified in CAST analysis?
Yes.
How long have you held that certification for?
I got certified in September of 2018.
Is there continuing education or recertification that's required?
Yes. So to keep your CAST certification, every year you have to attend a recertification course.
Okay. Is all of the training specifically from the FBM?
No.
What other agencies and I guess companies do the training for you?
Yes, we have partnerships, or not partnerships, but we'll bring in educators from a lot of different companies. So obviously the different telecommunications companies are critical. So we have them come to the recertification conference every year. We've had a range of other people. We've had Apple, Qualcomm, Oracle, people in the field of GPS, cellular engineering, vehicles for vehicle telematics. I mean, anybody that's sort of involved in that ecosystem.
Okay, so you mentioned Apple, Qualcomm. What are those?
Those are different manufacturers.
Is there also specific as to cellular technology and how it works, training on that?
For what?
In terms of being a CAST certification?
After recertification?
Yes.
Yes.
Okay. How long have you been specializing in call detail records analysis?
Further, I'm going to give Your Honor a copy of the order that was discussed about the report that was done by Judge Siegel. This was signed on April 4th of 2022.
Sure.
Are you intending to seek to admit the report?
Yes. And that's what that
Admit the report?
Yes, and that's what that.
Should we just object now that the reports are inadmissible?
I don't know what you're speaking of.
I don't think we admitted to admitting the report. We said we would
Excuse
agree.
me, I only want to hear from one. Whose witness is this going to be?
This is my witness, Judge.
All right, so you make the objection. So this is an order on the admissibility of expert witness testimony by Federal Bureau of Investigation Special Agent Brendan Collins. Let me read it. This is your order to judge. Says here, defendant stipulated to the admissibility at trial of the expert testimony of Special Agent Brendan Collins in the area of cellular phone forensics. This stipulation includes Special Agent Collins' testimony regarding the cellular analysis survey team CAST report, and based upon the defendant's stipulation, it is ordered and judged that Special Agent Collins' expert testimony in the area of cellular phone forensics and on the CAST report is admissible at trial. What's the issue?
So I believe counsel is trying to state that we are going to object to the admissibility of the CAST report. We had stipulated to his testimony after deposing him. And then I will also bring to the record, she's trying to bring in 3 different CAST reports. When we had deposed Agent Collins, we only had deposed him as to one CAST report. We had extensive conversations about whether the state would be bringing in the additional CAST reports. We had agreed at that time, if they were going to bring in those reports, she would let us know and we would depose him again. That never happened. We were always told it would be the one report of the 2 phone numbers, and which we are objecting to the admissibility of those reports based on hearsay. Also, they are misleading, and also the information in those reports have not been properly validated by an engineer.
Okay, so as of April 4th, 2022, what report was in existence as far as Special Agent Collins?
So the first one that was with regards to Anthony Williams' cell phone, as well as Mr. Demon's cell phone. That one was
What
done.
other reports are out there?
The other ones were generated in May of 2022 and immediately turned over to Defense Counsel, and I have a very different recollection of that. This was listed at the same time as Mr. Zeller that we just had, so there was never any additional request to depose this witness. But Special Agent Collins has been available for the last however long if they so chose to do so.
And Judge, I would just for the record make an objection to her characterizing that particular phone that is actually registered to David King as Mr. Demon's phone. I don't believe that has been established.
Thank you. So, what is the report?
Judge, I'm sorry, I didn't hear what you said.
I asked for the report. I need to know what the report says. I'm not familiar with it.
Yes, sir. So they're all substantially similar. They do different cell phones at different times. That one is the one of Mr. Demons and Mr. Williams, explaining how the cellular
Objection again.
explaining how.
I don't understand. I'm asked for what the report is. I want to see it, and you say objection again. What's your objection?
My objection is to the characterization. That it's Mr. Demon's phone. And
what is Agent Collins going to do?
Agent Collins would testify as to how he does the analysis, how he generates those timing advance bands, and what it means as to the location of the cellular devices based on the records, which is all done as a product of the accuracy of the records and the fact that the cell phone communicates in a consistent way based on the laws of physics with a cell phone tower.
Because in here, it talks about the phone 772-713-9807. T-Mobile says Jamel Demons. This and it goes below 954-248-9081. T-Mobile Anthony Williams. And it has the date of the report being May 12th, 2022.
Yes, Your Honor.
So this report date is after the order date.
It is. That is the second. It's the same one. It was all done at the same time. I believe, if I'm not mistaken, there was a typo that had to be finished on the spelling of the defendant's name, which is why it was generated at a second time on that point.
I respond to it.
You respond, you say what you want, counsel.
I would just say the simple fact that it has Mr. Demons' name on it, Mr. Williams' name, that needs to be stricken along with the other 3 reports, which were actually filed after we deposed them. It is my recollection that we were told in court that they would not be used. There was a question if Jameson Francois' CAS report would be used. She didn't give us a definitive answer. We finally rested on the fact that she was not going to be using Mr. Francois' phone. So it is a little bit of surprise that is now being introduced at trial. And the other one, I believe, with Withers, we never ever discussed it.
Hold on. Hold on.
Yes, sir.
I don't fully understand this order dated April 22nd. It says, order to judge a special agent Collins' expert testimony in the area of cellular phone forensics and on the CAS report. So he's going to testify. I wouldn't normally admit a CAS report. I don't see why it would come in here. I don't see this specifically saying it's admissible. I see it's saying Special Agent Collins' expert testimony in the area of the cellular phone forensics and on the CAS reports in this lawsuit. He can testify. He's here. You can ask him questions that you want, but I don't believe I'd be letting this into evidence. It's just, you know, he's here. His testimony is his testimony.
And so, with regards to that, the necessity of the maps is that the Special Agent Collins is going to testify in terms of latitude, longitude, and distances on that. Without a map, and using that for the jurors to be able to understand where this is being placed on the actual map, that's going in a vacuum.
Well, he can show it as a demonstrative aid if that's going to help him illustrate his testimony. I don't have an issue with that. That's a different question for me. Typically, we don't just admit an expert's report. You know, the expert's here is going to testify.
Yes, sir. Sorry.
And it's not clear for me from this order that that's what Judge Siegel anticipated, that the report was coming in. I don't have any issue regarding his testimony. You know, they're not even, defense indicated they're not even going to board hire him regarding his qualifications. So, you know, he's able to testify. But as far as the report coming in, I don't read your order that way, respectfully.
Understood. So, Your Honor, then if I can show the admissibility of the maps with that on there, then you would evaluate them as their authored individual.
I don't have an issue. I mean, if he's able to identify them and talk to them, that's a different issue. You're wanting to admit the whole report in as the way I understand it, as substantive evidence. And typically, that's not the way it's done. I mean, the testimony is the testimony of the witness. not the report, otherwise it's cumulative, it's be duplicative of whatever he was going to testify to. I don't see, the order talks about a date in April. This report was given after that date. I don't know if this is what the judge intended. You said there were some amendments. I don't know what the amendments are. I don't know if they were approved by the defense. They're saying they're objecting to it. Typically, that's just not done the way it's being done, putting in the document.
So, Your Honor, there are quite a number of cases on that specific issue, which I'm happy to provide the court.
What specific issue? About a report coming in?
About the maps and the mapping being admissible. So that would be...
I'm not concerned about the mapping. I'm concerned about the report per se.
Well, I just want to make sure we're clear on what specifically. So some of them, this specific items are demonstrative on that. So for example, when and I can put it up so everybody can see so it's clear. So Special Agent Collins, I anticipate, would testify that, for example, there is cell tower usage and how that would be displayed on that. So that wouldn't be confused with cell site usage. So that's because there could be the possibility that a juror would think, well, this is showing that the phone is somewhere in this purple area, which would not be correct, as opposed to, for example, a timing advanced illustration, which in this case, the witnesses can testify that the phone is somewhere in this band based on, and then as well as, so in terms of the way the mapping is then done, to make it clear and understand that these red dots are not the specific locations, but rather the towers that are used. I think it's important for the jurors to understand that and have the first part of that analysis there so that there can't be any sort of improper recall by the jurors on that. So then as to the locations on those, then this would be one of the timing advance. So if they don't have the other first part,
Judge, I think it's renewed again.
Excuse me, counsel. I don't think she's done.
Okay, sorry, Judge.
so it's more so the fact that the timing advance data and the way it is done, I don't want there to be any confusion to the jurors to saying that this is overstating the evidence. So if I just put in these particular items without the full explanation, because I don't think it is appropriate to do so without the jurors understanding the limitations of the testimony and what the different maps show. So on that would be the specific parts the state would be seeking to introduce, because the locations of the towers are important to how the math is done.
My understanding is the defense is objecting to that exhibit. Is that correct?
Yes, Judge.
Does that include the maps?
That does include the maps, Judge.
So they're objecting to it. So I guess you have, in some way, it has to come out how it was done.
Mm-hmm.
And you can talk to the witness and see if he can, authenticate it. Originally I was thinking that you were using him as demonstrative, and I would ask him if that helps illustrate his testimony or not. But if you're saying it, you're not concerned with that, you want to admit them into evidence. So the objection is, what's the objection?
That it's irrelevant. I would also object to the fact that
it's not relevant?
It is not relevant. It's also referring to Mr. Demon's phone. Nobody's established that number was his. It's referring to Mr. Williams' phone. You've got no testimony that establishes that it's Mr. Williams' phone. If we were to go to the other two reports, I don't know how the court's ruling on them. Again, she's referencing the phone numbers, assigning them to people. We have had no testimony or evidence before the court that those actual phone numbers belong to those individuals.
Thank you. So I haven't heard any phone numbers being assigned to any individuals.
If I may, Your Honor?
Sure.
That is why the state introduced the phone slip that has been brought in through the defendant's fingerprint, that he endorsed that as his telephone number, and as such, the state can now argue that. As to all of the other individuals, those are coming in from the phone records themselves. For example, Dungevius Withers and Chris Thomas, as I went through with the Sprint records custodian.
So let me start. What is the phone number that's on that pawn receipt that you're saying is Mr. Demons?
772-713-9807. And that's why we had the fingerprint analysis done, and they came in and identified that as the fingerprint of the defendant.
Thank you. And what's the next phone number?
The next two phone numbers that are the easiest ones to go through, Your Honor, are the phone numbers of Christopher Thomas, 772-713-2341. And if Your Honor recalls...
713-341. Should be another number.
772-713-2341. And I can bring up here for Your Honor the specific information on Mr. Thomas's phone that was brought in earlier through the Sprint records custodian. And there's the phone number at the top of the screen, 772-713-2341. Billing address for Chris Thomas.
All right.
Going down in the same records, because they were produced at the same time. In addition, the email address with it is Chris Thomas 86. Again, consistent with Christopher Thomas. The next phone number that is on this particular is 954-371-7895. And that is belonging to an individual by the name of Dontavius Withers.
Are there any other phone numbers this witness is going to be testifying with?
Yes, Your Honor. He would also be testifying on the T-Mobile records to the individual by the name of Jameson Francois, and to go to the subscriber information for Mr. Francois's phone. This is related to Miss Adria Scott, which there's been testimony that Adria, or AA, is the wife of Jameson Francois. In addition, that phone number for Mr. Francois, 954-376-9158, is consistently in the phone download of Mr. Demons and is listed as track. And there are plenty of photographs and things of that nature that would show and illustrate that Mr. Jameson Francois, also known as Track, is the owner of that phone number.
But it's actually in his wife's name.
Correct. And if you, the rest of the subscriber information also says it is a family plan with multiple lines.
Right,
Rate plan, family, unlimited, 2 lines included.
On the subscriber information for the first phone that you're suggesting is Mr. Demons, what does that subscriber information reflect?
That comes back to his mother, Jamie King.
Let's go back now. What's on I don't know what the exhibit number was. Did you print out anything on these phones? I think there was a printout. They objected to it.
There's multiple printouts on the phone, not all of which have been entered into evidence at this point, Your Honor.
But what's in evidence so far?
I can pull that up and just take a moment. This is in State 64.
This is the extraction.
That's correct. For example, 95446. Three 7 6 9158. There are 1,129 messages between the phone owner, Mr. Demons, and other individuals in which Mr. Francois is a participant in those conversations.
So again, you indicated this is Mr. Demon's phone. You just told me the subscriber information reflects that it's his mother's phone.
The plan is paid for by his mother. His mother's phone is in here. She is listed under Brazy, B-R-A-Z-Y, lady, and that's the 772-501-6942, which is listed as an additional number subscriber on the phone for Mr. and the phone records from T-Mobile from Mr. Dimmons.
Judge, I just want to point out, she's saying that these are messages between Mr. Demons and various people. This cell rate actually tells you, like she stated, like it's going to track, but it's coming from young Sat Chaser Howard, and he's registering as the owner of the 9807 phone, which in these reports keep going back to Mr. Demons, but in the cell rate is showing young Sat Chaser Howard.
And so in further showing as to who owns the phone, we can look at all of the videos and images of Mr. Demons, of which there are over 1,000 videos on the phone showing he is the user and owner of this particular device.
Judge, again, I have nothing that shows that he's the user and owner. It shows that whoever had possession of this phone took videos of Mr. Demons. They're not selfies. These are actually pictures that appears to be taken by another party.
Well, these are all videos, actually. If you want to go to the selfies, I can go to the 10,963 images to show some of those.
I don't know how she's determining their selfies, Judge, without a testimony to such.
So, for example, in this particular image, it's a screenshot of a FaceTime conversation in which the large image is going to be the person who's on the other line. The local device is going to be the tiny picture up at the top, which is of Mr. Demons. And this is just one of many, many examples.
And can you go back to the main subscriber information page?
In terms of this one? Yes.
So where does it show who the subscribers are?
This is from the device itself, Your Honor. This is an extraction from Celebrate of that phone in terms of information as to user accounts that are on this particular phone. You have YNW MELLY booking at gmail.com. You have YNW MELLY a Twitter account. You have YNW MELLY an Instagram account. You have Melly.Montana, the Snapchat account, which the Snapchat is already in evidence of showing that one. You have Jamel.Demons, a Facebook account as well on that. In terms of the content of the messages themselves as well, show that this was Mr. Demons' phone and that he is sending out information and things personal to himself on this. So there are multiple different types of information to show them.
So just if we were to actually go through all of these, I've informed the court before, you're going to see messages from both of the decedents to their girlfriends, to other people. There's no question that our client had used his phone, but so did all his friends. So this was a phone that they passed amongst each other. I don't think bringing up the Celebrate or a couple of selfies proves that it was actually his phone. For that argument, there's pictures of Michael Jackson on there. So can I say that Michael Jackson is well owned his phone? Based on her argument, that's what she stated.
$9081.
And that's Mr. Williams, one of the decedents, you're saying
Yes.
it's his phone?
Correct, that phone, and defense counsel is well aware of the fact that the phone that Mr. Williams had at the time of his death was recovered, and a full file system extraction was done from that phone that shows it was his phone on that, and as well as the fact that the Celebrate extraction that we just went through also has Mr. Williams saved under the name of Twin in the phone of Mr. Demons, in which there's discussions back and forth that identify the 954-248-9081 phone number as that of Mr. Williams. And that there's discussions, for example, that they have gone on trips recently. They've gone to, I believe it was Detroit, and there's then again photos of Mr. Williams on the phone of Mr. Demons in Detroit that are sent back and forth on that.
Regarding this witness, is he going to testify regarding Mr. Williams' phone?
He's going to testify to the locations of that particular cell phone, yes.
And they're going to be identified by phone number?
At both.
All right. Anything else?
No.
Anything else?
Just, if you're going to let it in for demonstrative purposes, I would say at the very least that the names are stricken from the reports and referred, or redacted, sorry. And we refer to only the phone numbers, not to the individuals.
Thank you. So we're going to bring the jury in now. As far as that demonstrative, I'm getting conflicting information. I don't want something going before the jury about this is Mr. Demons' phone or this one's phone. There's circumstantial evidence to that effect, but I'm not putting that in evidence that way. Just show the portion that shows the maps, and you can talk about the maps and the other things, but leave out the portion that has at the bottom, or I forget if it's the bottom or top, that identifies Janelle Demons' phone. Just use it by the phone number.
Use it by the phone number. Okay, that's not a problem. So I think I would need just a couple of moments to adjust that.
Go ahead.
Okay.
We're in recess.
Thank you, Judge.
What are the benefits of using LinkedIn?
Networking, big bullet point. Learning about different opportunities and different spaces that exist within the industry and bringing us together in a way that like we can support each other and learn from each other.
But counsel, I haven't, let's bring it back in. It is yo-yo, but I didn't say tell not to read. I'm worried about that.
Sure, makes sense.
Just bring it back in. Jury's coming in.